emergency and to protect the public, legislators, and employees, we must limit non-essential gatherings and adhere to social distancing and face covering guidelines. In compliance with those orders, the Senate has made necessary adjustments to normal practices in order to ensure that the public continues to have access to this legislative process. We are holding our committee hearings today in the Capitol, with some of our committee members participating remotely. In the Senate chamber with me are Senators Pan and Hurtado, Assemblymember Lowe, Chair of the Assembly Business and Professions Committee, Assemblymember Daly, and Assemblymember Grayson. We also have representatives from the Medical Board of California, the Department of Consumer Affairs Division of Investigation Health Quality Investigations Unit, the Department of Justice, and the Center for Public Interest Law, who are participating today remotely. As a reminder to all, please mute your phones or computers. This will greatly aid in eliminating any acoustic feedback. I ask that every time you wish to be recognized that you use the raise your hand feature in the program. Each time you are recognized to speak, a pop-up window will appear asking if you would like to unmute. Please select unmute before you begin speaking. Our IT personnel will put you back on mute when you are done. Once recognized to speak, please make sure you can be seen on the screen, state your name, and then you will be ready to address the committee. From my perspective, let me also add that when you speak, please speak loudly, please articulate, please speak slowly so everyone can hear you, both those who are participating over the audio or the video and those here in the chamber. To allow the public access, we have admitted members of the public to hearing rooms in the Senate gallery to the extent that social distancing requirements allow, and we will be using a telephone conference service for those individuals who wish to testify today. For all individuals wishing to provide public comment, the participant toll-free number and access code is posted on our committee website. It will be displayed on the screen, and I will announce it right now. Today's participant number is 844-291-6364, and the access code is 2961842. For detailed instructions on how the telephone conference system works, please refer to the Senate website or our committee website. For today's hearing, public comment may be provided on the Medical Board of California upon the conclusion of our panelists' presentations and following questions from members of the committees today. When we move to public comment, you will be prompted by a moderator to dial 1, then 0 for support and opposition. Press this only one. When we move to public comment, you will be prompted by a moderator to dial 1, then 0 for support and opposition. Press this for the moderator to call your line number. At that time, you will be unmuted, and you will now be ready to address the committee, and please proceed when instructed to do so. Please note that in order for us to hear you clearly and to avoid acoustic feedback, you must mute the device you are watching the hearing on prior to giving testimony over the phone. It is important that we hear from you, and we thank you for your patience during this extra layer of process. I will maintain decorum during the hearing, as is customary, and any individual who is disruptive may be removed from the remote meeting service or have their connections muted or be removed from these chambers. While every effort has been made to streamline the hearing process and to conduct our hearings in as close to the same manner as is customary, there may be some lag times for participants who are adjusting to the new use of online tools or technologies. Please be respectful and patient so that all interested parties may be heard. Sunset review oversight hearings, like today's hearing, allow for the opportunity to evaluate the effectiveness of regulatory and licensing programs and to determine whether changes in the law or in the program operations or functions are necessary. Today, we will be reviewing specific issues regarding the Medical Board of California's enforcement process and case outcomes. There will be one or more further hearings involving the Medical Board on other functions and processes of that board scheduled at a later date. Today, we will also have the opportunity to hear from consumer groups, professional organizations, and members of the public. At this point, I would like to invite Assemblymember Evan Lowe, the distinguished chair of the Assembly Business and Professions Committee, to make any opening remarks regarding today's hearing. Member Lowe.
Thank you very much, Chair Roth. I appreciate the work and dedication that the committee staff in the Senate put into this, as well as in the Assembly, and also the conversations that you and I have had about ensuring the public interest in the sunset, specifically with the California Medical Board. As members of the public may know, it is our obligation and our duty to look out for the best interest of all in the state of California, and that is what we are doing today with respect to legislative oversight and asking the difficult questions that must be asked. At the same time, it's important that when you hear about some of the conversations, if there is a violation of trust, we will do all that we possibly can to ensure a due process, as we know that similarly for licensees, this is about individuals' livelihoods. So I know that we will do our best to ensure that we'll advocate for the interests of all impacted at the medical board, and looking forward to the continued dialogue. Thank you very much.
Thank you, Chair Lowe. It's an honor to participate with you here today. Now, before we begin with our speakers, I would like to invite those members of the public who wish to participate to call in now. Please dial this toll-free number, 844-291-6364. When prompted, please use the access code 296-1842. We will now hear from Christina Lawson, President of the Medical Board of California. Welcome, Ms. Lawson.
Good morning. Can everyone hear me okay?
Yes, ma'am. Loud and clear.
Excellent. Good morning, Honorable Chair Roth, Honorable Chair Lowe, and members of the Senate and Assembly committees. My name is Christina Lawson, and it is my honor and privilege to serve California as the President of the Medical Board of California. I have served on the Medical Board of California since 2015, and I am one of 7 public members authorized to serve on the board. Professionally, I am a licensed California attorney and the managing partner of the Hanson Bridget Law Firm, and I am a former mayor of the city of Walnut Creek. As the leader of the board charged with protecting California's healthcare consumers and promoting access to quality medical care for all Californians, I would like to acknowledge the devastating and tragic impacts of the COVID-19 pandemic on communities and individual consumers throughout the state. Our heartfelt condolences go out to the families and friends of the more than 57,000 Californians who have lost their lives to the virus, and we express our appreciation to California's essential workers for their work on our collective behalf. We are pleased to have this opportunity to be with you today to talk about the board's enforcement program, which is critical to the board's mission to protect California's healthcare consumers. The enforcement program is one component of the board's portfolio of policy and regulatory duties and responsibilities, which also includes licensing and regulations of physicians, surgeons, and certain allied healthcare professionals. The sunset review process is an opportunity for the board and the legislature to have a collaborative dialogue, and we appreciate the opportunity to talk with you today about the enforcement process, including the constraints that the board faces in the enforcement process. As set forth in more detail in our Sunset Review report, and as we will discuss with you today, we believe there are a number of opportunities to improve medical board processes and enhance the board's ability to fulfill its enforcement duties and ensure California consumers are protected. We hope the legislature will partner with us to find solutions to protect all healthcare consumers and ensure access to quality medical care across California's diverse communities. Thank you again for the opportunity to discuss these important issues with you and to hear from the committee members and the many stakeholders. We are dedicated to moving the medical board forward to advance its mission and to build trust with the public. I would now like to introduce my colleague, the medical board's Vice President, Dr. Howard Kraus.
Thank you, Ms. Lawson, for your service. Welcome, Dr. Kraus.
Good morning. It's been an honor to be of service to the people of California during my tenure on the medical board since August 2013. I will be termed out on June 1. After receiving my master's in aeronautics and astronautics at MIT, I became a systems engineer with the Hughes Aircraft Company in Los Angeles engaged in the design of missiles, satellites, and spacecraft for the next 2 years. Seeking a more humanistic career, I left for medical school, receiving my MD at the ripe old age of 27, and then pursued 5 years of postgraduate education, since which time I have specialized in surgical neuro-ophthalmology, engaged in the evaluation and medical and surgical management of patients with neurologic, brain, facial, and orbital disorders which affect vision. I'm a physician and surgeon, a researcher and medical author, and continue to teach at UCLA, where I am clinical professor of ophthalmology and neurosurgery. One of my most important and humbling experiences began in August 2013, when I received a call from the governor's office offering this appointment. But over the last 7 years, I have learned that rocket science and brain surgery are easier than serving on the medical board. In my professional life, I have become accustomed to patients, families, staff, students, and colleagues saying thank you. I have enjoyed my relationships with colleagues and staff of the medical board, but seldom receive thank yous from physicians at large or from members of the public who appear or call into board meetings. In many regards, it's been a thankless task, but I have persisted because I know the value of this board. I know that despite the failures which may be highlighted at times, that this board is committed and dedicated to protecting the public above all else. As such, these 7 years of true public service will continue to be valued by me as a time of great significance, knowing that I and my fellow board members, our dedicated board executives and staff, and our dedicated colleagues in the AG's office and in the DCA have labored long and hard in behalf of the best interests of the people of California. I certainly agree with President Lawson that consumer protection is the highest priority and that our members and staff are dedicated to that mission. Today, I personally ask for the support of the legislature. The board hopes to enact multiple changes to the board's statutes, including some additional statutory enhancements that support its enforcement program. I believe that the board's proposals in our sunset report will lead to increased efficiency and collaboration between the board and its investigators who work on the board's most critical cases, including those that involve negligent or incompetent quality of care, sexual misconduct, and other serious matters. The board appreciates input from the legislature and stakeholders to find ways to administer our licensing and enforcement programs as efficiently and effectively as possible. And I would like to introduce our board's executive director, Mr. William Prasivka. Thank you.
Thank you, Doctor. Mr. Prasivka, thank you for joining us. I understand that you have a number of members of your leadership staff and other individuals joining us today as well.
Yes, Senator, thank you very much. I'm very pleased to be here. I'm here with my senior management team who will be assisting me in answering all of your questions. I have a presentation. I will thankfully be brief, but simply to highlight some very important points about the enforcement process. As the President and Vice President have very eloquently stated, that the protection of consumers is at the very heart of everything that we do at the medical board. And as a regulator who has had experience in a variety of regulatory affairs, can I tell you that I know for a fact that the Medical Board of California values consumer protection as its absolutely highest priority. In terms of an overview of enforcement, I welcome the fact that today we are talking only about enforcement, because as is quite apparent, enforcement is the largest function of the medical board. Literally 80% of our resources are devoted to enforcement, so it's very appropriate that we focus on this very important part of our statutory mission. I know one important issue that the committee would like to look at are the times that it takes to bring about an investigation and take a complaint through the entire process. The charts here demonstrate what those time frames are, charting out from the time in which all investigation was handled internally in the board up till fiscal year 13-14. And then after, there was a split between the sworn and the non-sworn investigations. We are concerned about the increasing timeframes. From an international perspective, I know that this is something that medical boards all over the world are struggling with because cases are becoming more complex, more litigious, and there are challenges. And one of the challenges that we have to face up to is the fact that the timeframes in terms of the sworn investigations have continued to rise.
Mr. Pacifica, before you leave that chart, I normally don't do this, but we might as well save some time here. Could you explain what that chart means? Are we talking about all cases? I see yours has an orange line. The orange line, are those the complex cases?
Those are the cases that go to the sworn side, which tend to be the more complicated cases, absolutely. And they have been increasing in time in recent years. The less complex cases on the non-sworn side, we have managed to make some progress in terms of getting the time frames down.
And this, before I go to my colleague, Senator Pan, and what we're talking about here is time from receipt of complaint to completion of investigation?
Yes, that's correct.
And of course, the other issue is how long it takes to move from completion of investigation to resolution. But let me go to Dr. Pan, Senator Pan.
Actually, it's, my issue here is at least sitting from here with, given the size of the print and where we have to look at, it's very hard. I cannot see the legends in the graph, so I'm going to need a little more explanation of, for example, what the colored lines actually mean, because in the print, at least I don't know for the other members of the committee, where I'm sitting, it's almost hardly visible. Oh, thank you. If we have a copy of the print, that's helpful. Thank you.
You would like a fuller explanation now, would you?
The chair has provided me a copy of the slides,
Okay.
which just allows me to actually read what's on the slides. I don't know if the other members in the committee are in a similar situation or not, but.
We'll try to get copies of that for the colleagues here in the room. I assume those on the screen can have a better view, those that are participating remotely, so we'll try to do that. Dr. Pan, any further questions based on? Okay, sir, I'm sorry to have interrupted, but I thought we might as well get that out of the way. Please proceed.
That's fine. Okay, going on to the next slide, looking at the overall statistics for complaints received. This is a very familiar statistic for those who follow us closely. We have been receiving on the order of 10 to 11,000 complaints every year. And at the end of the year, in terms of disciplinary actions, there's a fairly large consistency that we're in the 300 to 400 rate category. If you look at that in terms of the national context, it finds that the California Medical Board is, if you will, slightly above average in the terms of number of disciplines cases per MDs throughout the state. But the important thing here is to focus on that there are a large number of complaints that at a relatively early part of the process are closed out for, as it says there, insufficient evidence, no violation, or no jurisdiction. Sometimes we get literally hundreds of complaints about the same incident. And obviously, there's only one incident. There's effectively only one complainant. For those who are not familiar with the way the medical boards operate, sometimes this can seem a bit startling. But as someone who has worked in other areas, it's a funnel, it's a framework which is all too familiar. There are many cases that we receive that do not raise issues of fitness to practice. And what is needed in a regulatory system is the agility to deal with those efficiently and effectively, so that on the lesser numbers of very serious cases, we have adequate resources to deal with them in a comprehensive fashion. What I wanted to do was to highlight what the medical board sees as some of the drivers in relation to the timelines and resources that it takes in order to bring a complaint through the entire process. One thing which is very important is that we operate under a very high burden of proof. In order to get substantial discipline, the case must be proven according to clear and convincing evidence. And this is something that we're held to by the administrative process. And it is a heavy burden, but then again, if you're talking about a very serious sanction, that's a very serious matter as well. The other point that I want to emphasize is that the legislation requires that in terms of framing a sanction, yes, we look at public protection, and that is the primary object, the primary goal. We all agree with that. But we are also directed to look at issues of rehabilitation and practice restrictions, which would allow a doctor to remain in practice, provided that there are certain remediations or practice restrictions. From some quarters, there seems to be a drive, perhaps understandably, that most times there is a finding it should result in revocation. That is not what the legislation directs us to do, although it does recognize that revocation is necessary in certain circumstances. The other issue that is a driver in terms of enforcement is the institutional perspective, in that effectively enforcement currently is divided among three separate bodies: ourselves, the Medical Board, the Health Quality Investigative Unit, and the Attorney General's Office. This is, I think, an unusual configuration compared to other places, and it does present certain challenges, which we will talk about. The other driver that we need to talk about in terms of explaining and understanding why it takes so long, why it sometimes is so costly to bring a complaint all the way through the process, is that we have to follow a very cumbersome legal process, which requires most cases before any serious sanction can be considered to go to accusation. Now, accusation is a very important step. It requires the action of the Attorney General's Office, preparing a very lengthy document, which is necessary but very costly and very time-consuming. We have sometimes difficulty getting access to third-party records. We also have difficulties maintaining or obtaining patient records. And both of these things can be very time-consuming. Where we want to investigate, it takes sometimes a long time to actually get the records. And the other thing in terms of process is that under our current statute, there are significant limitations on any non-adversarial options that we may pursue. There is a public letter of reprimand, but that can only be invoked if it's agreed by the other party, and it's published, and there must be two simple departures. It is very frustrating for us if we have a lengthy investigation, and it is determined that there is one simple departure, and a simple departure may be something which is quite important, but then we have absolutely nothing in the regulatory toolkit in which we can bring the doctor through some remediation or rehabilitation. There's literally nothing we can do. There is a reference very briefly in our statute to warning letters, but they're non-binding, they're not defined, and there's nothing in them that we can really rely on in terms of having a serious means of dealing with a complaint. So we're looking for a few reforms. We are dedicated to working within the system, to working more effectively. And we believe that if there are certain reforms, we'll be able to work more effectively, more efficiently. We can bring the timelines down. We'll have more resources to focus on the very serious issues which require often a very serious and severe sanction. The first is to create what we have deemed to be a letter of advice, which would be non-public but binding. These would be for cases where fitness to practice is not an issue, but there is a need for remediation. We note that there are at least 21 other boards within the United States that have such a power. I know that internationally, the rest of the world is moving toward a focus on non-adversarial means of resolution for the vast bulk of the complaints, and that this is something which I think is needed very much as an option for us at the California Medical Board. As we've also stated in our sunset paper, there are a number of other enforcement enhancements that we think are very important, and they would allow us to effectively and efficiently obtain the records that are so vital for us in a timely manner so that we can investigate cases, and so we would certainly welcome their consideration. In terms of institutional reform, we think that there is a need for greater engagement between ourselves, the medical board, and the Health Quality Investigative Unit. We have already begun to do that. We are updating the memorandum of understanding between the two bodies. There is goodwill on both sides. Both sides recognize that there is a need to deal with these cases more efficiently and more effectively, and we are dedicated to working together, particularly to bring the timelines down and to prioritize so that we're using most resources against the most important cases. And related to that, we see that there will be a need at some point in the short to medium term to begin to consider moving investigative resources from the sworn to the non-sworn side. We believe that there is scope, again, to resolve a lot of the less serious cases more effectively, more efficiently, in a more cost-effective manner. And the goal here is, again, to free up the resources that are needed to deal with the very serious cases. Finally, I understand that the committee has some interest in the sanctioning policy of the medical boards. We have sanctioning guidelines and as to how they are used, and a concern that the guidelines are not followed appropriately. We'll be happy to speak to this at some length, but to emphasize a few points. The guidelines are guidelines only. They're meant there to provide guidance to the board. They are not meant to be followed exactly in every single case. And many times the guidance itself is expressed as a spectrum or of a variety of different sanctions. Settlement is a very important part of the process of dealing with complaints. It is actually mandated that we consider settlements in law as part of the process, and that the settlement is often a very attractive option for the medical board because it allows us to fulfill our mission of public protection if we can identify a settlement which protects the public and does so quickly, in a cost-effective manner, and with certainty. It is, the guidance is based on the assumption that all elements of the case have been proven and that there are no weaknesses in the case. In the real world, after an investigation is completed, after the respondent, the licensee, has had a full opportunity to state their case, sometimes things are not always so black and white. Sometimes the expert witnesses on the other side are very persuasive. We must take all of that into account. Sometimes witnesses do not say what we had anticipated that they would say. So in the context of fairness, in the context of pursuing the public interest, settlements are often very effective and very productive, but always they are done with the notion of public protection at the absolute priority. And we have procedural safeguards that are in place. Settlements can go before the board. Board members can raise questions. They can object. Those objections are considered. And it is frequently the case that settlements are set aside and proposed decisions are set aside for further consideration upon board direction. We welcome that. We welcome critical analysis of all settlements. We work very closely with the Attorney General's office. We listen to their advice. They have a lot of experience and expertise, but at the end of the day, the decision is with the medical board. And I'm confident that we have the right procedures in place so that other viewpoints, critical viewpoints, can be taken into account. That's the end of my formal presentation. And myself, the president, vice president, and our senior staff here at the appropriate time would be happy to answer your questions.
Thank you, Mr. Pasifka. Is Kathleen Nichols going to be addressing us as well?
Yes.
Thank you, Ms. Nichols. You are the Deputy Chief for the Department of Consumer Affairs Division of Investigation Health Quality Investigation Unit, if I'm correct.
Yes, good morning. My name is Kathleen Nichols. I am the Deputy Chief for the Health Quality Investigation Unit, also referred to as HQIU, at the Division of Investigation within the Department of Consumer Affairs. I am a sworn peace officer with over 25 years of investigation experience with the Medical Board and the HQIU enforcement programs. Thank you for the opportunity to join you today and provide an overview of HQIU's investigative process to protect the public. As you may remember, in July 2014, all sworn investigators and support staff were transferred from the Medical Board to DCA's Division of Investigation. The board's sunset bill at the time, SB 304, created the Health Quality Investigation Unit at the Division of Investigation. HQIU is comprised of 97 sworn positions, which includes 79 sworn investigators and 18 sworn supervisors and managers who investigate and supervise cases for the Medical Board, Osteopathic Medical Board, Podiatry Board, and the Physician Assistant Board. HQIU also employs 33 part-time medical consultants who work closely with the investigators to provide medical expertise and review of the evidence gathered during the course of an investigation. With 12 field offices located statewide, investigators receive referrals from the boards and investigate administrative and criminal violations of the Business and Professions Code, Health and Safety Code, and Penal Code. Before 2019, pursuant to law, the Medical Board utilized a vertical enforcement prosecution model, also known as VE. For the programs within DCA, the Attorney General's office is the prosecutor of the enforcement cases. Established in 2006, the VE model required the Deputy Attorney Generals to be involved in the Medical Board's investigation activities as well as the prosecution activities. Deputy Attorneys General and HQIU investigators were jointly assigned to an investigation from the outset. This team approach was intended to encourage early coordination and faster decisions and case filings. As you may remember, VE was discussed during the board's last sunset review and was ultimately repealed in law. Although VE was repealed, there are cases where an individual may be a danger to the public, where the Medical Board or HQIU will request for the case to be worked joint together. In these cases, the HQIU investigator works with the Deputy Attorney General to investigate the case expeditiously in order to gather evidence to request a suspension order. Since the elimination of VE in 2019, once a case is referred to HQIU for investigation by the board, investigators interview the complainant and witnesses, obtain certified medical records, and other evidence. Some case types require drafting subpoenas for records, obtaining urine samples for drug toxicology screens, setting up mental and physical examinations to determine if a physician is safe to practice medicine, conducting pharmacy audits, undercover operations, and issuing search warrants. After the initial information is gathered, all evidence is reviewed by a district medical consultant, a physician who works in the field offices with the investigators and who is also present for the interview of the subject physician. Once all the evidence is obtained and all the interviews are conducted, the case is then reviewed by an expert reviewer who is a physician in the same medical specialty or practice area as the subject physician. The board's expert reviewers are physicians in good standing who contract with the board to provide independent and impartial case reviews. Experts review the case materials and evidence gathered by the HQIU investigators to determine whether or not a departure from the standard of care occurred and to provide a written opinion. Reducing investigation timelines is my #1 priority. For example, I recently used existing positions to create a new Expert Procurement Unit, EPU. This new unit was implemented in October of 2020 and consists of 4 analysts and a non-sworn supervisor. EPU now handles the entire expert process for the majority of case types that need expert review. I am already starting to see the benefits of this dedicated unit to the investigator caseloads and expert opinions returning faster. I am also utilizing this new unit as a quality review point. I am personally reviewing every case that is submitted for expert review, along with the EPU manager, to ensure the HQIU investigation is complete to proceed to the Attorney General's office. After expert review, the completed investigation is returned to the medical board. If there is a violation, then the case proceeds to the prosecutorial pathway with the Attorney General's office. This concludes my overview of the HQIU investigation process, and I'm also happy to answer any questions from committee members.
Thank you, Ms. Nichols. Will we hear from Cristiana Dominguez, Deputy Attorney General and Legislative Advocate with the Department of Justice? Will she be speaking today?
Yes, sir.
Please proceed.
Thank you. Good morning, Chair Roth, Chair Lowe, and committee members. On behalf of the Attorney General, thank you for the opportunity to testify before you. My name is Cristiana Dominguez, and I am a legislative advocate in the Attorney General's Office of Legislative Affairs. With me today on the phone is also Chris Ryan, Chief of our Division of Operations. I'm pleased to be with you this morning to provide information about the important work of the Health Quality Enforcement Section, or HQE, within the Attorney General's office in prosecuting cases on behalf of our client, the Medical Board of California. Our mission at the Attorney General's office is to vigorously protect the health, welfare, and safety of the people of California. We provide quality legal services to the state's agency clients and regulatory boards. Since 1990, the HQE has prosecuted medical board cases in addition to 7 other healthcare oversight agencies. Another section in our office prosecutes cases for other regulatory boards within the Department of Consumer Affairs. As you are aware, our office handles prosecution of physicians for the medical board. HQE receives and reviews evidence collected by investigators in the Department of Consumer Affairs Health Quality Investigation Unit, which you just heard about. If sufficient evidence is found in the case file, the matter is assigned to a Deputy Attorney General, a DAG, who drafts an accusation, which is a document similar to a complaint or indictment, which is then presented to the medical board for the executive director's signature. A hearing before an administrative law judge with the Office of Administrative Hearings is then scheduled. Settlement negotiations generally next take place. HQE represents the medical board with a settlement posture approved by the medical board executive director. The physician will appear with their own representative. The majority of cases resolve at this stage through a stipulated settlement agreement that is guided by the medical board disciplinary guidelines. If no settlement can be reached, the case proceeds to a hearing with the administrative law judge who drafts a proposed decision that goes to the medical board. The board can adopt the proposed decision as written or increase or decrease the disciplinary penalty. If there is insufficient evidence to sustain a filing seeking discipline, then the case will either be returned for additional investigation and information or rejected. This is because, pursuant to case law, accusations against a California physician require a clear and convincing evidentiary standard, given that these cases seek to revoke or impact a physician's license in which they have a property interest. This is why we must base accusations on complete, reliable, and admissible evidence that allows us to make a reasoned and fair determination of whether charges should be filed. DAGs review volumes of complex medical evidence to determine sufficiency to support the filing of an accusation. We rely on medical experts who have reviewed cases and determined whether or not there is a deviation from the standard of care by the accused physician. Patient medical malpractice complaints are some of the most complex, technical, and voluminous matters of any of DCA's boards. If we reject a case, we provide a detailed legal memo to the client detailing the legal reasons the case cannot be filed. This is generally due to a lapsed statute of limitations. The timing for legal review decisions may vary due to the complexity of cases requiring extensive or complicated medical records, expert opinions, and other evidence. Further, given that the investigations are handed off to us by the Health Quality Investigation Unit at DCA, sometimes these files can take longer to work up if they come to us with insufficient evidence to prosecute under the clear and convincing evidence standard of law. That completes my overview. I'm, of course, happy to answer any questions from the committee. Thank you.
Thank you, Ms. Dominguez. We are now, I believe, we've concluded the presentations under Part A of our agenda. I'm going to open it up for questions. Before I do, I'd like to ask a few of my own. Before I forget this one, Ms. Dominguez, in the case of discipline of practicing physicians, and whether it's medical malpractice or some other similar alleged offense or violation, why is there a statute of limitations that necessarily applies as opposed to a case in the civil court for malpractice for damages or perhaps a criminal case?
Thank you for your question, Senator. The statute of limitations is prescribed by statute, so that's a policy choice that's made by the legislature. I don't have the legislative history in front of me today for that, but I would be happy to look into that and provide your office with more information.
What is the statute of limitations? I assume it's in the Business and Professions Code as opposed to the Civil Code or Code of Civil Procedure.
Yes, sir. I believe it is Business and Profession Code 2230.5. I believe it is 3 years. I'm going to try to fact check that very quickly as I'm talking.
Well, this is not Know Your Bible. I just want to make sure that that we have an idea about that, and we may need to revisit that at some point, because it occurs to me that if a physician commits serious malpractice and for some reason in dealing with medically unsophisticated consumers, the matter is not brought to the attention of the medical board to not be able to take action, I would think should be troublesome to some, if not many. But you've answered it. I appreciate it. Let me ask some more general questions. So the data you've provided, and certainly the data that we've been provided in our background material, indicates that you all receive somewhere in the neighborhood of over 10,000 complaints a year. When the medical board receives these complaints, does some agent of the medical board attempt to reach out to the complainants as part of a complaint clarification process to ferret out any additional information that, as I said, a patient, a consumer might have that might bear on the initial determination as to whether or not to refer the complaint from the central complaint unit to the investigation team? Anyone want to take that?
Yeah, Bill Persifka. We'd be happy to answer that question. It'll be directed to our head of enforcement who deals with these things on a daily basis, Jenna Jones.
Mr. Chairman, committee members, my name is Jenna Jones, and when a complaint is initially received by the board offices, it is initially triaged by our central complaint unit, and that is when they are looking at the complaint that has been received from the public member, other agency, or mandatory reporter, and we reach out to obtain a release, so we may obtain the medical records. And if additional information is needed, that is when we also reach out to the complainant and ask for that additional information.
Well, you say additional information is needed. I guess, you know, we had a Secretary of Defense once who used to say, "You don't know what you don't know." Is a body, an agent of the board, asking some preliminary questions of the complainant or complainants at this point in the process to determine whether there's additional information that should have been provided, or questions that should have been answered even though not asked, as part of this initial process?
Yes, and I will say that a number of our initial complaints come in anonymously, so that is difficult at times. Also, if we don't have a patient name, that's when we may be trying to reach out to determine who the actual patient was.
So do I understand the answer to be that in every case where we have the name of a complainant attached to a complaint before the medical board that is received by the central complaints unit, that an agent of the board reaches out personally and speaks to the complainant to ferret out any additional information that the complainant might have or might be able to provide that may bear on the decision whether or not to refer the complaint to the investigations unit?
Mr. Chairman, I will speak very honestly that if there is enough information and we have a signed release with the documentation that came in with the complaint, we may not reach out to them unless we need additional information or there are questions raised that are in the complaint. But we do reach out and advise them by letter that we've received their complaint, and they so they can reach and communicate with the initial analyst if they wish.
Well, just a couple more questions on this issue. Without a complainant interview, or at least some in-person contact where some give and take occurs, isn't it possible that the central complaint unit, in making the decision to refer or not refer, may not have all of the information pertaining to or bearing on the complaint? For example, a physician's failure to chart a particular procedure or issue that is the subject of the complaint.
If the allegation was that a procedure was not charted and we have the complaint and we've obtained the medical records and there's a discrepancy, that would move forward to our medical consultant for review to determine if it looks like there's enough information to move forward for a formal investigation.
Well, I'm not going to belabor this issue, but as a non-healthcare provider, albeit a once a long time ago lawyer, I wouldn't know to allege that something was not charted. You on the medical board would know, physicians would know, nurses might know, healthcare providers might know. I guess my question is, I'd ask perhaps as we move through this process that the medical board consider perhaps taking a look at this initial screening process, because if you are screening based on the face of the complaint and you send a letter to a relatively unsophisticated medical consumer, the consumer may not know what information it is that you might need in order to properly evaluate the consumer's complaint, and perhaps a more detailed, most of the time, in-person contact might be more productive.
Mr. Chairman, your point is well taken, and I will go about seeing what changes we need to make to incorporate that.
Well, let me move on to, I'm trying to get a handle on how many cases actually proceed through the formal discipline process at what stage. Our notes and my material reflected that in 2019-2020, there were about 347 cases referred to formal discipline out of that 10,000 plus bucket of complaints. Give or take 347. I think the number on your PowerPoint was a little bit higher. I don't have the PowerPoint in front of me. But of those cases referred to formal discipline, how many of those cases resulted in a stipulated settlement in 2019-2020?
If you can bear with me, I'm sorry, I'm trying to get my... So approximately 84% of cases that were at the stage ready for a settlement, there were 84% of the cases. My understanding is that after an accusation, there were 281 cases that reached a settlement. Now, according to the diagram that you showed, if I could just clarify, even though we started with 10,800 complaints coming in during that process, the 300 or bottom number of cases that were resolved or went to formal discipline, those may have been from the prior years and had just reached the point of settlement.
Right, but if your average is about 10,000, it's all sort of relative, isn't it?
Yes, sir.
So you had about 281 in 2019-20 that went to stipulated settlement, and my records reflect that you had about 44 of the total bucket of complaints, 44 cases that actually went to trial.
Yes.
Okay. Now, just a question regarding the process and processing time. I understand from the PowerPoint presentation that the time between receipt of complaint and completion of investigation varies somewhere between 300 and 500 plus days, depending on the complexity of the case. how long does it actually take to process a case from investigation completion on the average to stipulated settlement?
I don't have that number off the top of my head, I'm sorry.
Okay, well, you can provide that to our respective committee staffs when you are able to secure it. The same question for completion of trial. How long does it actually, on the average, does it take to process a case from completion of investigation to completion of trial? You may not have that question. In fairness, do you have it?
I'm sorry, I do not have it at my
Okay,
fingertips.
that's fine. If you could provide that to the committees, the staff of our respective committees when you have a chance. I've asked this question of other boards because I think it's important to have time standards and timelines, and I realize some of these timelines are outside of the specific control of the medical board, but I think it's important from our perspective to track how long it takes to actually process complaints through completion of the process, which either includes referral to formal discipline and stipulated settlement, or referral to formal discipline and completion of trial. On the stipulated settlement process, I know that was covered briefly during the PowerPoint presentation. How does that process actually work? Who reviews and initially approves the stipulated settlements?
Mr. Chairman, the executive director, the deputy director, and myself meet each week to discuss the various cases, and we review the settlement proposal recommendations from the Attorney General's office. At that point, we reference the guidelines, we review the information, we review the details of the strong points of the case and the possible weak points, and we grant authority to the Attorney General's office for settlement and the terms that we wish to have as part of the settlement.
Once a proposed settlement that's proposed to be included in a stipulated settlement, agreement, which my understanding involves an admission by the physician as to the commission of the act and other admissions and statements. Who reviews and approves that? Does the medical board itself in its entirety, or does the medical board delegate that authority initially to panels or groups of board members?
Once the initial stipulation is entered with this subject and the board on behalf of, or the AG Attorney General's office on behalf of the board, that document is forwarded to a panel of board members. There are 2 panels. Each of the panels reviews based on the alphabet. So one panel will review that case, review the stipulated settlement, and may approve or reject it. And if they will hold it if 2 or more people hold the case, it will go to the board meeting where they can have more formal discussion about it among the panel.
And the composition of the panels themselves, how are those panels comprised? 2 members, 5 members, 6 members, 5 doctors, 2 publics?
Ms. Webb, could you help me with the?
They have to have at least 4 members per panel, and how many members depends on how full the board is. Right now, we are short a number of members on the board, and so the panels are not complete, but they each have at least 4 members, and they are more physician members than public members.
And 2 two members of each panel, two members of a panel can hold a stipulated settlement and refer it to the board, the full board, for consideration?
No, initially, when the case comes in for the members to vote on, they do that electronically. And if two members of the panel hold it, then it goes to that panel for further discussion. In the case of a proposed settlement, the Deputy Attorney General who worked on that case will be invited to come in and speak to the panel to provide further details. At that point, the members can vote to adopt it, ask to change the terms, or to reject it and ask that the matter be sent for hearing.
Okay, perfect. Let me go over one final matter, and then I'm going to turn it over to my colleagues for more detailed questions on some of the specific issues associated with enforcement. But, you know, with regard to the board's disciplinary process, some of the complaints that some of us have received and staff has received go to the contention that the board has been slow to act when it either knew or should have known of cases of alleged physician misconduct. There was a report in a Bay Area newspaper quite recently where it was alleged that a county's chief pediatrician had sexually abused young boys ages 6 to 16 in his foster care arrangement and as part of his patient cadre for a number of years. And according to the report, although the county prosecutor didn't charge him, in 2011, the county district attorney's office notified local criminal defense attorneys, as the DA has a duty to do, since this chief pediatrician was a witness in criminal cases, that there was substantial evidence that the physician committed multiple crimes of moral turpitude, specifically sexual assaults. It's my understanding that same year in 2011, the county fired him from his chief pediatrician position, and then in 2013, the state, California Department of Social Services, barred the physician from working with any children or adults in state-licensed facilities. Now, the newspaper reported that it was not until February 19, 2021, 10 years later, that a medical board accusation was filed by the Attorney General seeking to revoke the physician's license. Obviously, these are news reports. Obviously, probably many, if not most of you, weren't around in 2011. But it seems to me that there's a lot of government action involved here with a number of mandated reporters over that 10-year period. So my question to the medical board, if you can answer, is why it took so long.
Well, Senator, the simple answer to your question is that the medical board can only react to the evidence and to the complaints that are made to us. And here, according to what the information that I had, it was only until the complaint was made to us at a much subsequent time that we had any basis to act at all. That previous to that point, the primary jurisdiction was with the criminal division of the prosecutor's office, where it should rightly be.
Well, listen, that makes
when complaints are made to us, we can investigate them.
I hate to interrupt, but that makes absolutely no sense to me. The medical board itself can initiate a complaint, can you not? You don't have to wait for a consumer or a county district attorney to file a complaint. Under your rules, can the board itself not initiate a complaint against a physician?
We can initiate a complaint. We can initiate against a physician, or we can initiate an investigation, provided we have the evidence to do so. But we are not a primary investigative body. We don't go out searching for complaints. If things come to our attention through whatever means, of course we can follow up on them. But largely, we are a reactive body. We have to wait for a complaint, and it wasn't until much later in the process that the information came to our attention, which allowed us to act upon it.
Well, I'll be interested to see the reaction of some of my colleagues to the statement that you are a reactive body. Seems to me that as a state licensing and regulating entity, you have a duty to protect the public. That's certainly in your mission as your primary mission. You have the authority to initiate complaints. You have, as per your PowerPoint, what appears to be a sufficient number of investigators in various units to conduct investigations, and I would suggest to you that as part of your own internal review process that you may want to take a look at this process, because and if nothing else, to take a look at the mandated reporting rules when it comes to physicians and medical practice, because somewhere along this 10-year path, the process broke down, whether it was, and I realize you all probably weren't there, but I'm talking about the institution itself. There needs to be a way to recover information and to evaluate information and to proceed with that information where the facts dictate that action is appropriate. I'm going to turn it over to my colleagues now and let them continue to ask questions as appropriate. Senator Pan.
Thank you, Chair Roth and Chair Lowe. Actually, I do have several questions, but maybe the first question I want to just follow up with what Senator Roth asked. So just to clarify, the medical board, I do understand is sometimes challenged in terms of identifying issues that may be going on. You mentioned certainly one of the things that triggers an investigation are complaints, and you receive many, as you've documented here. But can you just also maybe perhaps discuss a little bit, for example, what other sources of information the medical board gets that might trigger complaints? So I think legal actions against physicians, whether civil or criminal, do those come, if it involves a person licensed by the Medical Board of California, those come to the board, or someone scanning for that? Of course, there are other things that show up in other types of databases. I think the federal government maintains certain databases as well in relation to certain types of behavior by physicians or other providers. So can you speak to the role of those types of sources of information in potentially triggering investigations or complaints separate from, so or let's say the cures database, right? You see someone's prescribing a large amount. Now that's not a complaint, but someone's outside of the range of the, so can you just speak to your process and looking at those sort of data sets, and I guess in Senator Roth's case would be potentially, I assume there was some criminal or civil action that might have taken place by the prosecutor, or maybe it didn't. Can you just speak to how that might trigger investigations?
Yes, well, thank you very much for the question. Look, there are a whole series of databases and reporting mandates that we can use to trigger complaints and investigations. There is a database, for example, of all discipline actions that take place across the state medical boards in all 50 states. Those come to us, and they give us notice about a licensee who has been subject to an action in another state. There are a whole series of reporting mandates dealing with civil actions in terms of malpractice suits, dealing with the restriction of privileges to practice at a variety of different institutions. They all come to us. They are all very useful. But at the end of the day, in all of those, we're dependent upon the reports that come in to us. Again, I would like to ask our Director of Enforcement, Ms. Jones, if she can supplement that answer.
And actually, before she begins, in her answer, could she also perhaps address the question of how many investigations have actually been triggered by those databases, or that type of information, separate from an actual someone filing a complaint, directly with the board? So has that ever triggered an investigation on its own? And if yes, how many? How often does that happen?
Yeah, I think we have that reported.
Let me just find that chart. We receive complaints from a number of different sources. Malpractice settlements that are over $30,000, we receive reports on those. we initiate an investigation based on that.
And just to clarify, so if you see a civil action of that size, do you wait for someone to actually send you something, or do you, when you see it, you go, oh, we're going to start an investigation? Or not, or you look at it in more detail? So I want to try to discern between someone actively having to submit something to you, say, please, please, please investigate this, versus you're scanning these data sets, hospital staff, civil cases, et cetera, and saying, oh, we see something here that we think we need to start because a judge made a certain ruling or medical staff made a certain ruling about a behavior of a licensee.
Well, in the case of medical malpractice cases, we are not scanning the court records. If someone identifies something prior to the settlement is being reached, we will look into it, but there is a mandatory reporting under the 801.01 section where they have to report the malpractice settlement amounts to us. We also have the coroner's reporting. Criminal charges are required to be reported. The numbers of malpractice reports in fiscal year 1920 were 542. But I will be honest, we do not regularly run checks on the civil court system to check for malpractice cases that may be pending.
Okay, well, let me say, but you said you do receive reports of anyone, and by the way, I should point out the research shows there's very little correlation between malpractice suits and actual quality, but I want to put that on the side. But you are receiving, you just told me that you are receiving these reports, right? So if you have a civil case that results in a award or finding of over $30,000, you will receive a report that happened. Does that ever in itself cause some further examination of whether that's a circumstance the medical board, or do you actually have to wait for someone to say, please investigate this? So you're going to get information from hospital staffs who've taken disciplinary action against physicians. We have potentially criminal cases have happened that involve licensees. So I'm trying to discern between you do receive, as you said, when I say you do receive information about some of these things that you just told me, do those in itself then lead to further examination by the medical board that may then trigger a fuller investigation and potentially action by the medical board?
Yes, sir.
Okay, and how often does that happen versus someone actually filing an active complaint?
Every case that we receive a notice on, for whether it be malpractice, a criminal charge or arrest, we're opening all of those complaints and reviewing them.
Okay, so one of the things that might be, and again, maybe you may not have the details here, so we can follow up later. So for example, the example Senator Roth just gave, you testified that you didn't receive the information until very late into the process. I guess the question is, what caused that delay? Was it because, and maybe there wasn't a legal action that then sent a report or something, but I think that's certainly something that's that high profile where there was a lot of, as Senator Roth said, a lot of government activity somewhere, something you would think would have made its way to the medical board earlier now. So it might be useful to look at some of these types of cases and go, well, what happened? Is there something that why are we not getting the information we need to say that, oh, maybe something we need to look into as well, especially since it involves a licensee and it involves something that's fairly serious in relation to their practice or their behavior in practice?
We will be happy to research that, and I will provide that information to the executive director.
Okay, so that, all right, so I just wanted to follow up on that and also clarify in terms of what sort of, because I know the medical board does look at a lot of different things, or let's say there's a lot of different sources of information. So let's just move on.
May I speak to that issue?
Sure, yeah, okay, before I move on, yes.
This is Howard Krause.
Sure.
One of my frustrations in service on the board is that government agencies and even different boards within the DCA and different organizations don't have enough collaboration. So there's also a semantic issue here. When we speak of complaint, we're not meaning to say that a member of the public needs to fill out a report and make a complaint. A complaint is something that we become aware of. We also read the newspaper and become aware of things through the newspaper. Over the years, upon reading an article in the newspaper, I sometimes will call the board director and say, what about this? And generally, by the time I become aware of something in the newspaper, the board is already investigating it. Similarly, there was a recent case where the medical board was investigating a complaint, and the LA Times wrote an article that they called the Department of Public Health, because there seemed that there also could have been a failure to report on the part of a university hospital system. And the Department of Public Health said, well, we have no knowledge of this. So since that time, I know that the medical board has reached out to all associated organizations and is building relationships such that we can let one another know when we become aware of an issue that may reach across multiple boards or multiple departments. Regarding the specific case of pedophilia in San Francisco, I would assume that the board began investigating it when the board became aware of it. So it would be helpful to view this as a sentinel case and to look over all of the government agencies that investigated that case and viewed the case and find out why that had not been reported to the medical board sooner. So one of the things that I would hope would come out of issues such as this would be for the legislature to help us in assuring that we have a greater collaboration between government departments and a greater sharing of information so that things don't fall by the wayside. But again, semantically, a complaint by definition is any charge or concern that comes to the board's attention, whether it be by reporting from criminal systems or civil systems or hospital reporting of disciplinary actions. So that is something that we call a complaint. I wouldn't want the committee to think that by complaint we're meaning that some member of the public needs to make an additional complaint in additional to our becoming aware of it.
Okay.
But once we are aware of a circumstance, then it is investigated.
Okay. Thank you so much for that explanation. Appreciate that clarification of what the term complaint means. And I do think that we should look at some of these cases where it seems like the medical board was delayed in taking some sort of action in terms of at least investigating, and whether there were other steps that could have been taken that made the medical board aware earlier. And certainly would appreciate the medical board's help as well. So we don't want to do things that aren't effective. Okay, I'm going to move on to next question I have actually. So I know one of the issues, of course, is that your revenues are your expenditures are lagging your revenues, and then we're talking about trying to make things more efficient. But I would just make note that in your report, the Medical Board of California notes and that 88% of applications it receives and reviews are deficient at the time of review. Now, why am I bringing this up? So we're talking about people who are applying to the Medical Board of California for licensure. These are people who apparently successfully applied for college and got through the college process and probably knew how to fill out an application, who then applied to medical school and was able to complete and have medical school application fully without too much trouble, and then applied for a residency. So we're not talking about people who aren't used to applying for things. And yet 88% of the applications were deficient at the time of review. Seems to me there's a systems problem there. You take a group of very smart, talented people who know how to apply to things, even complex applications. I'm a residency director, so I know what a medical school application looks like, and yet seem like they cannot follow instructions, or something is going on with these applications. And I will point out, though, in my own personal experience, full disclosure, I'm a licensee of this board. Now, this was a while ago. For example, one of the hang-ups that happened in my license application is that they wanted a letter, a proof of residency from my residency director. I provided it from the existing residency director because the person who was residency director at the time I did my residency had passed away. And yet the medical board said that was not acceptable. I need to get it from my actual residency director, who unfortunately was in the grave and was unable to provide the letter, although I'm sure would have been happy to do so if he was able to. And so that went round and round and round, and probably, I don't know how much staff time that took for me to try to explain that, reject, who do you want a letter from, because I unfortunately can't get it from, et cetera. So and then the other actually interesting problem that hung up, and again, it's not about my application, but I'm just saying, like, how much time does it take to do this? Right now, actually, the board's moving toward institutional licensure for residency. Apparently, Massachusetts did have that at the time. That wasn't good enough for the Medical Board of California at the time. So we went round and round about my licensure as well, and finally we got that straightened out. So I guess my question really, though, boils down to, how much time and money are we spending on reviewing these applications? If 88% of the applications are deficient at the time of review, are we not being transparent enough with people who are applying? Why are we making it so hard for people who are very experienced in following very complex instructions and providing very complex documentation, and they've proven it through at least 3 different cycles of applications in order to even get to the point where they could apply for a Medical Board of California license? Is there, I mean, can we talk about efficiency here? It's one thing if it's like 10%. I can't imagine this group of people, 88% of them can't figure out how to fill out an application that isn't deficient unless the instructions are very poor.
Yes, okay, I will ask our General Counsel, Ms. Webb, to deal with the question.
Thank you, Senator Pan, for that question. And I think you hit it in part, that part of the reason why there's deficiencies upon first review is that the board does require primary source documentation for medical school and residency programs and passing of the required exams. This is a consumer protection issue to make sure that the board
Okay,
is...
all right. And I appreciate that, but let's put it this way. I had to provide primary source information for applying to medical school from college, and then when people applied to residency, and by the way, as a residency director, we needed certain primary source information, and yet I didn't have this rate of deficiency in applications from people who applied from medical school to my residency program. So I think if it was clear, unless the requirements, and I guess I point out my own example, but that's only an example, it's not data. But when you have requirements that you can't meet, all right, like asking for a letter from the very person who happened to pass away, but are we making it too onerous? I mean, I could provide a letter from the program director who actually was practicing, who had access to those records. I could have letters from the institution, but it was not made clear in the beginning that, if your program director actually isn't there, and passed away or something else happened, that these were the alternatives that would be sufficient for the board, which really are still primary source. I mean, the program director would still be pulling up the same records and going, oh yeah, no, he completed residency, his faculty said he was fine, et cetera. And there's actually always a letter in the file as a residency director that I write at the end of every year when we have graduating residents that we put in the file saying, yes, they have completed, in fact, I have to certify it to the AC, to other people as well, but yet, so again, primary source, I mean, these people know how to follow instructions. If you said I need I need this from this, this from this, this from this, they can do it. So why is it still 88% of people still cannot follow those instructions? Either something's wrong with the instructions, or we're being unreasonable. And the problem is that it also involves not only the applicant's time, it's the staff time to go and send their letter rejection saying you need to da-da-da, et cetera. But yet there isn't enough clarity that people can't do it, that 88% of the people still have a deficient application at the time of review?
Thank you again for that question. 2 points to make. First, I'm glad that the board was able to resolve this issue with your application.
Don't know how long that took, by the way. Yeah, so months, which delayed, of course, my, So anyway, fortunately, I applied early, so it didn't, but it delayed the application by months and months and months, because we went in circles and circles and circles. So I don't know how long the staff took to go and tell me that every alternative, et cetera, and they didn't tell me what to do, so I had to keep trying different angles and so forth, and they kept insisting on it. I kept saying, do you want the death certificate from the person who passed away? Is that what you need? I'd have to go talk to his family and see what he could give me a copy.
The second point I want to make is that it's not a lack of following instructions in most cases. It's that the applicant has applied. They've already sent their requests out to the various entities where the board needs primary source, and the board is waiting for that information to come in. So that it's deficient because the board is waiting for that information to come in, not because the applicant didn't understand the instructions.
Okay.
The
All right.
third point I want to make is that the board is making huge improvements in this with its new docs portal. And so this has created huge efficiencies and has made it easier for programs and schools to upload documents that has streamlined this process. And we are going to continue moving in this direction. Things that the board has learned from COVID has expedited this change, and the board will be asking for assistance from the legislature to improve efficiencies even more.
Okay, I appreciate that. I just think this is very symbolic, potentially, and I appreciate, so hopefully you can continue to inform us as to the improvements that you're making, but I just, I've heard from many people who, of course, fortunately, you may only apply once and then, you get licensed and renewals a lot simpler, but it really, I've heard so many horror stories about people trying to apply for a license here who, it's not an issue of them being good standing, it's an issue of really just, a lot of, well, anyway, I'm just saying, and I also want to figure out what the cost of that is to the Medical Board of California, because that's staff time too, to keep, when you have that level of errors. Okay, well, let's move on here. I don't want to belabor that point.
Dr. Pan, just to let you know, we're going to have a second session of the Medical Board oversight hearing that covers licensing, cost recovery, fee structure, financial solvency, structural deficits, and all the rest. Just in case that bears on your question.
Okay, yes, all right, no, thank you, and I will. And we have many excellent members of the board, but I have to admit that, and this perhaps does bear on eventually in terms of enforcement oversight. Standard of care and evidence, and where some of the board members made statements that were somewhat concerning in regards to at least certainly an issue I had great interest in. Can you just speak to that, because obviously that will have some bearing if they're playing roles in investigations.
Yes, I would be very pleased to address that subject. I can assure the Senator that standard of care is at the very heart of what we do, and it's at the very heart of the role of the board member. During the short time that I have been there, we have had presentations at board level and training on the issue of standard of care, and it's something which is regularly reviewed and consulted on. Obviously, any time that there is discussion of any individual case, any particular sanction, the standard of care is absolutely critical to that point. So the review of every case, we would hope, reinforces the centrality of standard of care.
Okay. Well, I appreciate that. I said I have absorbed some board hearings which that has led to some concern on my part that sometimes some of the board members may not be as aware of public health evidence and standard of care, but appreciate that explanation. just go flip through here. All right, well, I will, I think most of my other questions involve licensure, which I understand will be taken up at a subsequent hearing, so I will leave it for then. Thank you, Mr. Chair. Chair Roth.
Thank you, Senator Pan. I have Chair Lowe, Assemblymember Fong, Senator Hurtado, and Assemblymember Grayson in the queue. And as I'm steering this back toward enforcement, I just want to put a couple questions on the record that I would appreciate having responses delivered to the respective committees. One has to do with board self-initiation of inquiries, and I'd like to know how many board-directed inquiries on doctor misconduct without prior complaints were initiated in the last fiscal year and certainly the fiscal year before that. And I'm not talking medical malpractice necessarily, physician misconduct. That's one. Given the fact that we have a state agency in this state who took action in 2013 on that pediatrician that I referenced earlier, I'd like to know when the medical board began to take action with respect to the doctor's behavior. And basically, since it's been published in the newspaper, I'd like to see a timeline on the medical board's activity with respect to that specific case that I cited. If there are any questions regarding the information requested, you can let me know now or before we conclude the hearing, or address it specifically to the chief consultants for both committees.
If I could just ask, just by point of clarification there, by terms of the first question you said, complaints are where we've initiated an investigation without a prior complaint. Are you including there the mandatory reports that we receive?
Yes.
Okay, so these would...
Because frankly, sir, I'm bothered by your initial comments indicating that you're sort of a reactive regulatory agency as opposed to a proactive regulatory agency, and I want to get a feel for and a handle on what exactly you do in the absence of consumer complaints. And I'm particularly bothered by the fact that we have a California State Department of Social Services, I believe, that took action to bar this physician in 2013, and it was not until 2021 that an accusation was filed. So I think a timeline on this particular case would be instructive. And
yeah, no, I wasn't asking a question about the timeline in terms of the particular physician, but the first thing you were talking about was where we had initiated investigations without a prior complaint.
Right.
And now, without a prior complaint, are you including there the mandatory reports we get in terms of malpractice, restriction of practice? Do you include that as a complaint or not?
No, I don't include that as a complaint. I include that as you receiving information that should cause you to, and by the way, you focused on malpractice. I'm talking primarily about physician misconduct, criminal activity such as that, and I want to make sure that I have a handle on how reactive the board is or is not when the board knew or should have known, based on the information existing out there, of physician misconduct that, whether it occurred or not, should be investigated. Okay?
Okay, that's understood.
Perfect. Chair Lowe, questions?
Thank you very much, Chair Roth. I want to join in the conversation back to Chair Roth's commentary directed to Mr. Pacifica regarding the article specifically that happened from the county that I represent in Santa Clara County. Mr. Pacifica, are you familiar with the article at hand from the Bay Area News Group that was published February 23rd?
You'd have to give me some more means to identify it.
Are you familiar with the article published on February 23rd titled, "After Decades of Sex Abuse Claims, State Moves to Stop Former Santa Clara Chief Pediatrician from Practicing Medicine"? Are you familiar with this article?
Well, I'm familiar certainly about the case, yes.
Yes, okay. You stated earlier, it was brought also to your attention just a few moments ago by Senator Roth about the case at hand, and I was particularly struck and disturbed by your response stating that you have to wait for a complaint to be made first. Can you help me summarize, help me understand that as to why you believe and why you stated, or maybe you can clarify your comment that you stated that you believe that you must wait for a complaint first?
Yeah, well, I thought Dr. Krause explained it quite clearly. We have to have information that gives us a basis for going forward. Now, the information comes from a variety of sources. The obvious one is through the complaints process, but there is public information. There are mandatory reports that come through us. We get anonymous complaints, which again create certain problems because there's no one to follow up. So there are a variety of bases upon which we can take action. The difficulty that I have is that, for example, right now, on the basis of no information, we are not seeking to see if there is someone who is problematic in some place we have never heard of or don't know exists. We have to have something to go on. Now, it can be a variety of things. We follow up on newspaper accounts or other media reports, but we have to have a name and we have to have some basis upon which we can collect information.
So you don't believe that the role of the board is to be proactive?
Well, no, it is in the sense that I have just said, but we have to have some information that gives us the basis to go forward seeking further information.
May I speak to the question?
Sure.
This is Dr. Krause again. If I may have the privilege of interpreting, again, semantically, what we mean by reactive versus proactive. We have to have information to react to. But again, we don't require someone to send in a report specifically to the medical board saying, so-and-so did this and, did you read the newspaper? So a newspaper article does come to the board's attention, but we don't have staff that reads every newspaper, so there could be some articles that don't come to our attention. As I said earlier, generally by the time I read something in the paper, the board's already working on it. What is meant when we say we're not proactive is we don't have a staff of a dozen people who are hanging out in hospital lounges and street corners overhearing conversations to pick up on circumstances wherein somebody may be misbehaving. But we never ignore information. We never ignore concerns. We don't read of someone who may be misbehaving in a newspaper article and say, well, let's not do anything about that until someone sends in a complaint to the medical board. So I don't want that to be misunderstood. We're proactive once we have information, but we don't have a cadre of people who are out in the woods and in the streets, so to speak, overhearing conversations to collect information. So I fear that we're getting hung up on semantics. And the suggestion that was made earlier by Senator Roth to look at this Bay Area case as a sentinel case and to see where in the chain of events there was a failure to notify the medical board by one agency or another agency will be very instructive. There are some cases where there is mandatory reporting. And if indeed the legislature can help us to increase mandatory reporting so that more things become evident to the medical board, that will be very helpful in protecting the people of California. So help us obtain that information, and we will be very proactive as well as reactive in terms of investigating and doing our job to protect the public.
Okay, thank you, Mr. Krause. You keep bringing up the word semantics. This is not basically semantics, as I interpret your comments to be somewhat condescending. This is about being very direct. This is not about going into the woods. It's as simplistic as having a Google alert for California Medical Board or the failures to act specifically not passing the buck on trying to say that we're not being proactive. We expect more. This is a legislative oversight hearing for the medical board. I think it's a failure for the board, specifically on the ownership of the headline of that report. So back to the executive director, how do you interpret the publication itself? Do you interpret that as a failure of the board?
What is the date of the publication?
Sure, the date of the publication is February 23rd, 2021, just but a month ago, not too long ago. And the title reads, "After decades of sex abuse claims, state moves to stop former Santa Clara chief pediatrician from practicing medicine."
Yeah, that's because, prior to that was when we had filed the accusation, which is a public record. The accusation was published as a result of an investigation which was initiated previously at the soonest possible date that it could, based on the information that we had. It then went through a process. It went through an investigation. It had to go through the Attorney General's office, who provided the information and the expertise to bring it to the accusation level. So the action that we took was done at the earliest stage that we had the information to act upon.
Is this a failure of the board?
Well, okay, well, I would welcome an opportunity to look back in time as to what was happening 10 years ago and to look at the information that the board had available to itself. But if you look at the severity of the accusations there, it is quite obvious that this is a criminal law matter, primarily. And that's, I think, where we should look at in terms of investigation, initiations, contact with the social services, failure to report there.
Okay.
And I would be very happy to look at what information the medical board had 10 years ago and to see if we had a basis to take action back then.
Well, thank you very much. As your board vice president said, I don't want to get into semantics. That was a lot of words. I just asked a simple question. Is this a failure of the medical board? Yes or no?
Well, the simple answer,
Chair Lowe, may I?
No, thank you. I'm asking the executive director, is this a failure of the medical board, yes or no?
Well, I'm not prepared to answer that question in that way now without knowing the facts.
You don't know the facts. Where does the buck stop? Does the buck stop with you? Who's ultimately responsible?
If there's any problem with the medical board today, the buck stops with me, full stop, no excuses. We are always looking to do better. The current executive team does not believe that the status quo is good enough, and we are striving to improve things. But I'm not going to throw my former colleagues under the bus without knowing the facts.
May I speak?
No. I would just like to, the ultimate authority, just about it. I don't want to get into semantics. This is just about very straightforward. How is it that you do not know the details of this case, being that it was made public but a month ago, and you knew that we were having an oversight hearing? How is that possible?
Okay, what I know are the details of what the medical board has done, and that's in the public documents there. Now, what you're asking me to do is to tell you what happened 10 years ago, what information was available in the public domain, and should that or should that not have been the basis for an action by the medical board. I don't know that.
Okay.
May I speak?
And then who, if you will not take ownership of this as executive director of the medical board with a simple question, is this a failure of the medical board, then whose failure is it?
I think I've answered your question.
Chair Lowe, may I speak? This is Christina Lawson. Yeah.
My question is directed to the buck stops with the executive director, and I'd like to ask directly to the person who has accepted ownership.
I have answered your question, Senator. I will not be bullied into making any kind of statements that have no basis in fact.
May I speak?
No. Thank you. I'll finally say that if your interpretation is that of asking a question about the accountability for the state of California and that we are doing our job, the necessary constitutional job of oversight, then it is to be interpreted such that we are asking the tough questions of the failures of the work that where the buck stops with you. And that is our obligation to be able to do. And if you're ill-equipped to be prepared, you'll see subsequent oversight hearings for us to hold you accountable since you've taken ownership as the executive director. Thank you.
May I speak?
I'm finished. Thank you, Chair Roth.
May I speak?
Absolutely, please. This is not, you have an opportunity to respond. Any of the...
You know, first of all, I would like to apologize. I was born and raised in the Bronx, and sometimes I'm cynical and sarcastic, and sometimes I appear to be condescending, but no comment that I meant today was intended to be condescending. And if I come off that way, I humbly apologize. I have a great deal of respect for the committee and for the process that we're going through today, so never hesitate to call me on how I behave. Second of all, as I witnessed the back and forth between Senator Lowe and Mr. Pasifka, I also frustratingly witnessed a misunderstanding. Mr. Pasifka seems to feel that Senator Lowe's question was directed toward what action did the board take or not take 10 years ago, whereas I heard Senator Lowe's question to be what action did the board take or not take subsequent to the article published in the Bay Area News in February. As Senator Roth said earlier, we need to look at the timeline. We need to look at this case. We need to take it as a sentinel case, and we need to see step by step, when was there public information? When were there government agencies involved? When did the medical board become aware of this, whether it be through the print media, TV news, or any other circumstance? And then we will know whether or not the board failed. I would not sit here and be honest and say that the board has never failed, but I don't think any one of us know in this particular case at this time whether or not the board failed, and I wouldn't rush to judgment. So please give us the opportunity to investigate the timeline of this case and then answer the question. Thank you.
Thank you, sir.
Chair Roth, if I may just offer a couple additional thoughts on that point.
Absolutely.
Thank you. On behalf of the board, I think there are a couple of things that are going on here when we talk about whether there's a failure or not. There can be a failure in our process, and as Dr. Krause just articulated, we are happy to investigate that and understand precisely if and when and where there was a failure in one of our board enforcement processes. But there's something else going on here, which is one of public trust and accountability and the credibility of the board. And so it is these types of cases where the public has invested a deep trust in the medical board to protect them, to make sure we are looking out on their behalf. And there may certainly have been a failure here to do that, failure to communicate what our processes are. Perhaps we weren't doing a good job along the way. And so I take that role and responsibility very seriously, although that public trust role, of course, operates outside of our statutory authority in the Medical Practice Act or some of the other directives. So it is incumbent, and on behalf of the board, I know all the board members would agree with me, that's something we're certainly focused on working on and improving and making sure that we have the trust and credibility of the people that we have been entrusted to protect.
Thank you for those remarks. Member Fong.
Thank you, Chair Roth and Chair Lowe. I wanted to ask about the settlement issues and the role of the board. If you look on page 61 of the analysis, and I don't know if that's available to you, it highlights a situation that occurred in my district in Kern County. And the paragraph, I'll just read it for those who, if you don't have it in front of you, says the negative impact on patients stemming from settlements can be significant. For example, in 2000, one physician entered into a stipulated settlement for violations that occurred in 1996 and 1997. The physician was placed on probation for 3 years. The physician was restored to full license status in 2003, but again placed on probation for 5 years based on a settlement. The board's most recent accusation filed against the physician cites gross negligence, repeated negligence, and failure to keep adequate and accurate records related to the wrongful deaths of a patient and her unborn son last year. So I guess, could you provide some clarity in terms of, and I know you talked about this in your presentation about how the guidance, the disciplinary guidelines are guidances, but not mandates. But could you, I guess, highlight or shed some light in terms of how you come to a conclusion that may not be at the level of the guidelines, and then talk about how the board monitors physicians on probation for something like gross negligence or wrongful death accusations?
Yes, well, certainly, as we have said, the guidance is there to provide guidance. Settlements are done in the context of each individual case, looking at all of the relevant facts. We look at, we begin with the accusation. We look at the expert reports. There may be contrary expert reports. We look at the quality of the evidence. We always have a view as to what is the possible outcome going to be if there is no settlement and if the case goes to hearing. We obviously look at the outcome, which we understand in this case was very serious, involving the death of a patient. But the issue that we have to face up to is related to the standard of care, which cannot be driven exclusively by the outcome. You can have a very poor outcome and there is no violation of the standard of care. You can have a satisfactory outcome and there is an extreme departure from the standard of care. It's the standard of care and the quality of evidence that relates to decisions that are made on the basis of settlement. And settlements are driven by what we consider to be in the public interest in the context of each case. There may be a view taken that the settlement achieved is better than is likely to be achieved if the case were to go to hearing. You've asked the question about the monitoring of conditions on the basis of probation. And maybe if I could turn that over to my colleague, Ms. Jones, on the enforcement side.
Oh, sorry, you're on mute.
The terms of probation, am I on
Yes,
now?
Yes.
Sorry about that. We have probation monitors throughout the state that oversee the probation terms of each licensee that is on probation. Their role is to initially meet with the person that's being placed on probation, go over all of the terms of the order to assure that they're clearly understanding what the terms are and what will be expected of them. And then they have quarterly in-person meetings with the individuals and follow up with if they have a monitor, they're following up with the monitor, they're reviewing records, reviewing charts. It just depends on what the terms of the order require.
And are these monitors, are they based in each county, or is it by region, or how is that structured?
They're based out of the throughout the state. They're in the. I'm not sure if it would be region or county, but they co-share offices with the HQIU offices, so they're throughout the state.
Okay, and then I mean, certainly this is a very tragic and concerning situation now that this is a repeated situation. So in terms of, and I guess going back to the settlement issue, is that clearly that has to be taken into account in terms of the guidelines and discipline?
Yes, sir.
And then, so then how does the board determine whether a licensee is rehabilitated or fit or competent to practice? I guess in this example cited in the analysis, and of course in my district, it said that the license was reinstated So what goes into that process and what goes into that decision?
Well, as was indicated, this is handled by the probation office. They monitor all the terms and conditions of the probation. And at the end of the term of probation, or in some circumstances at an earlier stage, if it has been demonstrated that all of the conditions have been met, then the licensee is eligible to come off probation. And so it's all done in that context.
So then, I certainly want to kind of delve a little deeper into that. I mean, who's involved in the assessment of whether a settlement should be different from the guidelines? If the guidelines are there to be guidances and the decision is to be made to do something that is not to the same level as what's recommended, I'm struggling to understand how that's possible. What's the purpose of the guidelines if you're going to come up with something that is not to that level?
Okay, it's very simple. The guidelines are based on the assumption that all elements of the case have been proven to a clear and convincing standard. They're based on the assumption that there are no additional factors of mitigation that are necessary to be taken into account. So all of those things have to be taken into account. The process by which a settlement is entered into is that the initial agreement to propose a settlement is a collaborative effort between the Attorney General's office and the executive, which is the executive director, deputy director, and the head of enforcement. At that point, then, if we agree with the recommendation or we fashion a new recommendation, it goes into settlement. There may or may not be an agreement. If there is an agreement, then ultimately that goes for review before one of the panels. And the panel has an opportunity to object to the settlement or to question it, in which it will go to a hearing at which the parties will be there. The Attorney General will be there to explain various factors that were taken into account. And then the panel has the ability, under certain has the ability to reject the settlement. So that's, if you will, the procedural safeguard that is taken into account.
So in that process, then, can I ask, who makes the initial recommendation? You said that there was kind of a number of agencies and entities that are involved. Does the Attorney General's office make a recommendation, or is it a collective decision first amongst the board and the AG, and then it goes to the panel, to the board?
Well, the way the general process works is an initial recommendation is made to the executive by the Attorney General. And then that's a matter of discussion. Sometimes we accept it, sometimes we accept it with conditions, either up or down in terms of level of severity. That's the initial point. Now, there is no settlement until you have two parties who agree to it. Then it goes to the other party. There may be some negotiations. If there is, nothing is done without the approval of the executive. Then you reach a settlement, and then it's eligible to go to the panel for review.
Okay, but you had stated earlier, and corrected me if my facts are wrong, but 84% of the cases filed before the board result in settlements. Is that correct?
That's correct.
So do you
Last year.
That was last year.
Last year, I'm sorry, last year, just to clarify. I appreciate the clarification. Do you have, in general, and maybe, and I know I need, maybe if you could provide me with the specific data at some point, maybe not here, but how many times is it normally accepted, the recommendations accepted, versus it being changed or rejected, or is that just an ongoing thing?
Well, first of all, you have to understand that we work very closely with the Attorney General's office. We have a very lengthy relationship with them. We've been doing business with them for a long period of time, so they know what our ethos is, what our recommendations are, and they really have internalized a lot of that in terms of their own work. So by and large, when we get recommendations from them, first of all, we always find that they are very well put together, that they are deserving of careful analysis, we wouldn't reject them lightly. But the medical board and the executives, we have a different point of view. We have a different experience. We have different views of individual types of cases. And there's very constructive give and take between us. At the end of the day, the decision is with the board. The Attorney General is our advisor. We are the client. But we find that their advice is very good. It's always something that we take into account. And the one thing that the Attorney General's office has is very good intelligence and experience dealing with the administrative law judges. So they have a very good intelligence about what's the likely outcome going to be at hearing, which is very important.
Okay, but it just, and I just want to emphasize this, that, I mean, it's stated in the code, right? The protection of public health shall be the highest priority. So yes, in the settlement decisions, that is the, I mean, that is the goal.
Absolutely. We don't agree any settlement that we do not believe is in the public interest. Full stop. Now, there's a very recent case. I don't want to get into the details of it, but there was a recommendation that it should go to settlement. And the view was that there was a settlement proposal, and we said no, simply because we thought it should go to a hearing. There was a conflict of fact. Now, it is not clear how that will be resolved. All these cases are black and white. But I certainly believe that there is a significant conflict of fact between the parties. That's where you want to have a hearing, because let the fact finder make decisions based on the credibility of the evidence, which is something that you can't do just in the basis of a paper settlement. So we have differences of opinions, but that's a very constructive thing. We get good advice, we respect the advice, but at the end of the day, the medical board makes the decision. And again, we don't recommend any settlement unless it's in the public interest.
Do you, and I noticed that you had a number of reforms in your PowerPoint presentation. Are there additional reforms to the settlement process that would improve patient protection? Do you see any additional changes that need to be done as the process continues? This is certainly something that I'm concerned about. I'm sure my colleague from Kern County and the senator following me will probably be asking very similar questions about repeated situations of negligence. These are, and of course, the result of wrongful death is tragic. And yes. So, are there reforms that can be done to improve this process?
Okay. Well, first of all, we have not included any such reforms in the current sunset proposal, but I can certainly assure you that this is a very important area, and that we are willing to listen to any constructive advice or decisions to improve the process. We think it's very important. Again, the settlements have the advantage for us of certainty, in that we know we are going to get a solution which protects the public interest. And that's something we wouldn't have in the absence of settlements in many of the cases. But we are certainly open to considering improvements of the process, but none of those are part of our current sunset proposal.
Okay, and I apologize for jumping around, but I do want to ask this question. When it comes to probation, does that normally limit a physician's scope of practice? I mean, is that part of the settlement agreement as well?
It doesn't always limit the scope of practice. Many times there are conditions that are put, whether it's training, there could be mandatory testing in the appropriate cases. Sometimes there are limitations on practice. Sometimes there are limitations on solo practice. There's requiring a practice monitor, but those are not always the case. The conditions are tailor-made based on the case that the conditions arose out of.
I certainly appreciate your candor. I would say that probably maybe the area that we need to focus on is the monitoring part, and maybe to do that better. You said that it was like quarterly meetings and check-ins, and that may not be enough, and that may be something that we might want to make more robust. But I appreciate the opportunity to get information, and thank you, Chair Roth, for the opportunity.
Thank you, Member Fong. Senator Hurtado.
Thank you, Mr. Chair. And I apologize if I'm a bit scattered here. As you can see, I have a lot of paperwork and therefore a lot of questions. I know that perhaps some of the board members are familiar with me. I sent in a letter with several questions in August of last year. Not fully happy with the answers that were provided to me, so I'll go ahead and ask some of those again. I do want to just briefly go over some of the information that I pulled out of the website, the DCA website, of the complaints for the fiscal year 2019-2020. The board received 10,868 complaints, and they closed 12,903 by the complaint unit. My first question is, can you please explain or give us an understanding of what the complaint unit does, the role, how do they make the determination of closing a complaint that was sent in? Because I know you said it was about 85% of that, that are closed during, within this unit. But I mean, are we talking about like frivolous claims then at this point? I mean, what goes into determining closing a case within the unit?
Thank you for your question. This is Jenna Jones again. So there are a number of factors that go into the initial review of a complaint or matter. When we talk about the 10,000 complaints that were received during the fiscal year 1920, there may be cases pending from the prior fiscal year. So that's where you're going to see the number increase to the 12,000 figure you presented, because we have cases that are still pending review and finalization or determination. So that's where the number can be increased. Now, the types of complaints that may be closed at the initial review may include cases that were, using cases and complaints synonymously. I'm sorry if that causes any confusion, but a number of complaints we receive are out of our jurisdiction. They either need to go to the nursing board, the osteopathic board, or one of the other allied health boards. So we identify those as not being licensed with our agency or under our area, and we're going to refer those out. So last year, I believe that was, oh, that's a different graph, I'm sorry. There was approximately 1,300 complaints last year that were outside of our jurisdiction. I'm sorry, non-jurisdictional last year were 1,600 complaints, 1,694. It also, we may not have jurisdiction over it. It may be a billing issue. It may be something that doesn't fall under the unprofessional conduct. And then, so the initial review also includes, if we get an anonymous complaint, do we have any information? Do we have a patient name? Trying to identify somebody that we can go to or gather additional information. The anonymous complaints can be a huge amount of our incoming complaints, and therefore, sometimes a number of those are closed. There's just a lot of factors involved. Sometimes we will send a request for a release of medical records, and we send a couple of requests, and we don't get a response.
But is there a process, and who reviews these complaints? I guess that's what what is the internal structure for determining where a case or a complaint should even be filed or moved towards, or is out of the jurisdiction?
Okay, so when the complaint first hits our office, it's going to go to our triage unit, which is called the Central Complaint Unit. That is their role, is to triage that complaint or amount of information, a TV report, news article, the malpractice report, an arrest report, whatever that may be, that is evaluated by the Central Complaint Unit and started on the process of moving towards being sent for more investigation. But our initial steps are.
But the majority are in the Central Complaint Unit. The majority of the complaints are closed within this unit. So I'm trying to figure out who are the decision makers within this unit that make the decision to close a complaint.
The analysts, we have a staff of analysts and managers, and they are the ones that are reviewing the cases. We also send those cases before a medical consultant group, and they're helping us review the cases to determine if the cases appear to have a possible violation.
So my understanding is that a complaint doesn't go to a medical consultant unless it's considered now an investigation. Is that accurate?
That is not accurate. The cases that we receive the records on, that we're able to obtain records on, and we feel that there may be a possible violation, those all go to a medical consultant review. The medical consultant review is in accordance with one of the statutes 2220.08, where someone who has similar training and experience reviews the records, and determines if there's a possible violation in the matter. And that is, once we clear that hurdle, then the case goes out to HQIU or CIO for further investigation.
Okay, and I know you did mention at the beginning there that there's analysts and managers at triage within the complaint unit, right?
Yes, ma'am.
So do you believe that they have, or they're prepared to provide the proof or an understanding of the standard of care?
Mr. Tato, or Senator, they're not determining the standard of care. They're evaluating it to present it to the medical consultant, who is a licensed physician who will be determining if a standard of care was violated.
But some don't go to the medical consultant, right? I mean, they make the determination if it goes to the medical consultant next. Is that accurate?
Well, if it's a situation where office staff were rude to the allegation is that the staff from a clinic were rude or something, you're correct. That would not go to a medical consultant. And that is a case that we don't necessarily have jurisdiction on. If it's regarding a physician's care. So, yes, I'm not going to say every case goes to the medical consultant, but if it's involving patient care, yes, it is going to the medical consultant.
So what percentage would you say ends up going to the medical consultant of the cases that come in?
I would be happy to research that and get you a number. I'm sorry, I don't have that with today.
The other question I have regarding the central complaint unit and/or when a complaint goes to the medical consultant, is there any screening that is done through the National Practitioner Data Bank?
We receive complaints, or we receive reports on the National Practitioner Data Bank, and we initiate complaints from those. That's a little bit different process because it's usually based on another out-of-state practice or out-of-state action.
Which one? Can you explain that to myself and others listening in?
Absolutely. So if we receive a report from the National Practitioner Data Bank, that could be action taken by a hospital. We're going to follow up and see if we already have an 805 report, which is a mandatory report on that. It may also be an out-of-state action taken against a physician, and that's going to be initiated and a complaint's going to be initiated, but it's going to be considered an out-of-state case, and that's when we start getting the information from the other state, and we take a look at it that way. We don't have jurisdiction to obtain all of the records from the hospitals in those states, but we're obtaining the other state's action that they took against the licensee and moving forward with the complaint or case based on that matter.
But you have the ability to go into the database and look up a doctor that maybe there's a complaint about in front of you and get background information as to whether or not there's been disciplinary action in the past in some other state in regards to this doctor.
We're actually going to have that in our database.
So are you reviewing your database at the moment? And does that have information about disciplinary action in other states?
If it's been reported through the National Practitioner Data Bank, yes, it's going to be in our database.
So you take that into account in terms of, do you take that into account or the information when you're doing the triage?
We're going to look at the entire history, yes. It all depends on what the matter was. Is it current? Is it 10 years ago? So it's going to be evaluated, but it depends on the details involved.
Okay. And I know that there was mention of some sort of document that you received or notification if there's an individual that received disciplinary action in another state, or then you look into it and then you, I'm assuming you revoke the license at that point.
It would depend on the discipline taken in the other state. If they were given a public reprimand, we usually generally follow what the other state has done with our own action, but it would depend on the seriousness of the action taken in the other state.
Okay. Now I want to shift a little bit back to the medical consultants. My understanding is that in terms of the medical consultants, you have, they're permanent intermittents or they're part-time. Can you explain a little bit more about their actual role, if they're actually state employees, how often they come in? And I know there was mention that there's about 33 consultants that you have, medical consultants.
The medical consultants, for the most part, are independent contractors that we have there's more than 33. You may be speaking, we have a full panel of medical consultants. You may be focusing on the number that are involved with HQIU and serve them directly. We do have a chief medical consultant that is on staff, but the other medical consultants that we're referring these cases to are not full-time employees of the board. They're all contractors.
So they're contract employees, they're not state employees. Is that correct?
Yes, ma'am.
Okay, and I know there's also expert reviewers. Are those contract employees as well?
Yes, ma'am, they are.
Okay. And how many expert reviewers do you have?
I believe the last number in the pool was somewhere over 600.
Over 600?
Yes, ma'am.
Do you know how many do you have per specialty?
I could get that information for you. I do not have that at this moment.
Okay. I want to also just briefly mention that I represent the parts of Fresno, Tulare, Kings, and Kern counties. I did some more or additional research. I looked through the active licenses with disciplinary action with no public document, there's about 248 active licenses with disciplinary action, and with a public document available, there's about 146. I also wanted to mention that there were 140 licenses that were surrendered, but some after the fact. And I think that you touched on this just a little bit earlier, that when you get the notification, the national notification, then you take action. And it seems like that's the case. And so that's why I asked earlier if you looked into if you did kind of like in a preventive way, looked at the database to look at, or look up doctors that have complaints against them, because it just seems like a lot of it seems like there's not a lot of information that is being collected from there, or that we're informing ourselves from that national database. So I wanted just to point that out. It's just a statement.
Okay. I'm not, yeah, thank you.
Let me just. So I know that in my original question, or the letter that I sent last year, one of the first questions I asked was, can you please provide a review of why license revocation was originally considered as part of a disciplinary action but was not issued? Do you have any additional comments or a response to that?
If I can take that up, Senator, it's the form of pleading that is done as part of the legal process in the accusation stage is that we set out a whole range of what possible sanctions may be available. But it's only after the conclusion of the investigation that we have a better sense as to what is achievable. So it is routinely stated in accusations that one of the options is revocation. But that does not mean that that will ultimately be the appropriate sanction.
The other topic I wanted to kind of cover is probation monitoring. I know there's also, when a doctor has been disciplined and there's someone that actually monitors them locally, why are the names kept confidential? I mean, if I am I'm a consumer, right? I'm concerned about, I want to make sure that I go to the right doctor, but there's a doctor that's been disciplined in my region. I mean, if I have even a complaint about a doctor or have some concerns, how do I express those concerns if we have no knowledge of who that individual is?
You mean who the probation monitor is?
The one that works directly with the doctor, locally. Is that what they're called, probation monitors?
The board employee that would be monitoring the doctors on probation would be our probation monitors. I am not aware that she or that individual has not been, I understand that individual has had contact with the high-profile case that I believe you're referring to, but I was not aware that their identity was confidential.
So probation monitors information is not confidential, it's public, is what you're telling me. I can have access, or if I call in, I can get that information if I request it.
Gary.
I will double check on that.
Okay.
May I get back to you on that?
Sure.
Thank you.
Do you have any guidelines set up? And it seems like you kind of just, it's a case-by-case basis, but do you have any sort of guidelines that you use to issue citations and/or probation?
Yes.
Can you explain that a little bit?
If an individual on probation is determined to not be complying with some of the, either a specific term of a probationary order, the first step is a citation process, depending on the extent of the violation. But a citation may be utilized to address noncompliance.
Okay. Now, does a consumer have the ability to file, I don't know, some sort of, if there's an outcome in a particular complaint and/or case, does a consumer have the ability to disagree with that outcome and petition once again?
The individual complainant may certainly write us and let us know that they're unhappy or displeased with the final outcome. But as far as amending that outcome, I am not aware that that is an option because the matter has already become public and has been finalized.
I mean,
but we certainly take that into consideration.
After the fact, I mean, isn't this board about patient protection?
Yes, ma'am.
Okay. But there is a process for doctors to be able to do that kind of thing. If they disagree with the outcome, they can file some form of
Yes,
counter complaint. Is that accurate?
Senator, if I could address that question. Yes, you have pointed out to what many people in other jurisdictions have thought is an anomaly in the Act. Basically, the complainant is the medical board. The doctor is the respondent. If the doctor is not happy with the outcome, there is a right of appeal. There is no such right of appeal about the complainants. Now, in other jurisdictions, what they do is they have another board which has a right to appeal decisions on the basis of public protection, and particularly on the basis that the sanction is not sufficient to protect the public. For example, in the United Kingdom, there's a body called the Professional Standards Authority, a sort of a regulator of regulators, which has that role. That's not what we have in California. There's no right of the complainant, like, for example, the patient, to appeal.
Right. That's
correct.
Okay. My next question is, what proportion of cases investigated by the board are cases that involve patients using Medi-Cal versus commercial insurers?
I don't know that we have that information, Senator. We'd be happy to try to get it, but I'm not sure that's captured on our database anywhere.
Okay. Well, I could be here all day and ask additional questions, but I will leave it at the moment as is. Thank you for your answers.
You're welcome.
Thank you, Senator Hurtado. Member Grayson, followed by Senator Pan.
Thank you, Chair Roth, and also Chair Lowe as well. And I understand today's hearing, the subject matter is specifically on enforcement. And so in reference to your PowerPoint, the slide right before the last one, it talks about forms required, and first a statement, and that is just simply this, that having heard the testimony and the back and forth, especially about the news article, I now see the first bullet point as closer engagement between MBC and the investigative unit as under institutional as a reform required. That statement there speaks volumes now, and I would even probably include the Office of Attorney General as far as closer engagement. My question is, the second bullet says increase flexibility to move investigative resources from sworn to non-sworn staff. What would be the benefit or the improvement that the board is expecting or looking for from having increased flexibility? And what exactly does increased flexibility and resources mean?
Yeah, I will be happy to begin the answer to that question. There is a concern that we're having sworn officers in too many cases to do work that could be done by non-sworn officers. The effect of this is the direct effect on costs and on timelines. So we're looking to be as efficient as possible, as this is in the backdrop of a medical board that has a looming structural deficit. So what we want to do, and this is what we want to do in a number of areas, is to deal with each case appropriately. We believe that more cases can be dealt with in a non-adversarial fashion, which means that they can be settled at an earlier stage, and remediation can be initiated faster and in more cases. Similarly, we believe that there are many of the adversarial cases that can be resolved by non-sworn personnel faster and in a more efficient way. And at the end of the day, the goal here is to free up resources for the very difficult cases, the very serious cases, many of which can be quite complicated, which are very strenuously contested, and we need to have more resources for those. So that's the goal in all of these reforms.
Thank you.
Thank you, Member Grayson. Dr. Pan.
Thank you, Mr. Chair, and I appreciate the opportunity just to ask a couple more questions related to enforcement. First question actually is a little bit of follow-up from Senator Hurtado. So certainly there are circumstances in which a physician who is found to be deficient or negligent, in which they're placed on probation and their practice needs to be supervised. Now, I know in one case of a physician who basically showed poor documentation, also had a record of writing inappropriate exemptions for vaccinations, that part of the board's discipline included for probation, included supervision by another physician, but interestingly enough, he got to select that physician who was supervising him during his probation. Is that normal course for the board? I find that, why would the person who actually committed the violation get to pick the person who gets to watch his performance going into the future during probation?
Senator Pan, I believe that what happens is they present, the licensee presents options to the practice monitor, to the probation monitor, and it's a process that they have to go through a process of evaluation and understanding. They can't work with them. They can't be related to them. It is supposed to be at an arm's length.
Well, that wasn't certainly indicated in the documentation, and I think it's apropos to Senator Hurtado's question. Shouldn't the medical board itself take on the responsibility, perhaps working with local professional societies and so forth, to identify an independent monitor instead of relying on the very physician who's being put on probation to identify their own monitor?
Yes, I will. I agree with you, and I will certainly look into that.
Yeah, I mean, I appreciate you saying they have to be arm's length, except you're asking the very person who's being punished to identify some potential candidates. That's not arm's length at that point. As soon as they're involved, it's not arm's length anymore, no matter who because there's, I don't think that person's exactly an objective person to be asking who should monitor their own deficiencies. Okay, I'm glad we have agreement there. The second one, actually in the same case, it was interesting that, there were several, again, I appreciate, and this, several steps that the medical board did take. But one of the fascinating parts, though, is that, the underlying problem that led to his being sanctioned was not actually prohibited for him doing in the future. So he wasn't banned from writing further medical exemptions. Now, subsequent law has changed that circumstance, but shouldn't the person who is deficient in the area that they are being probation, shouldn't there be some circumstance, shouldn't the sanction also involve, at least certainly if it's not essential to their patient care duties, not engaging in the very behavior that triggered the reason that they're being placed on probation, or obviously they're license suspended, they can't, but they're being placed on probation. Shouldn't that be always included in the sanction for the physician who's
Senator,
probation?
If I could interject here.
Yes.
All of these settlements and sanctions are very much bespoke. They rise out of the circumstances of each individual case. It may be the case in certain types of cases that it's appropriate to have a prohibition order in relation to the conduct under question, but that is not always appropriate in every case. In fact, I would think prohibitions in practice are something which would be more the exception rather than the rule. It all depends on the facts of each individual case. We would be happy to look at in any more detail at any individual case, but just to say that the sanctions, they're meant to be very specific to the facts of that case.
Let's put it this way.
They don't all go across to the same formula.
Okay, well, I understand there isn't a formula, but let's put it this way. If part of their sanction has to deal with their abuse of their authority, of the license authority, that has an impact on public health, right, or enables fraud, and it isn't directly related to the actual care of, their provision of clinical care, I would think that someone who engaged in that should be prohibited from being able to continue to do that. So if they, let's say, miscertified disability payments, they provided incorrect information to state agencies or local agencies using their medical license authority to allow patients to essentially either receive services or benefits they weren't entitled to, or be able to perform, put other people at risk. So because you have a public health function too, you're an agency of the state, that why should we continue to allow them to have the privilege of being able to continue to either endanger our communities or continue to defraud the public, especially if that's one of the reasons why they were being, one of the reasons of the complaint and one of the reasons they're being sanctioned.
Senator, I can assure you that we have taken a fresh look at these cases. Issues of financial fraud are things that come too frequently before the medical board. I take the view of pretty much close to a zero tolerance position in these kinds of things. There are a number of very serious concerns that arise. One is the financial fraud, because it's a fraud, as you identified, on the entire public health system. Secondly, I have deep concerns that a physician who commits financial fraud is, well, not the kind of person that really should be a physician, full stop, and is likely not to provide the best care to patients. So I can assure you we take these things very seriously. We have engaged in discussions with the Attorney General about the appropriate course of action in these types of cases, and we have taken actions to have much more strenuous and strict approaches to these cases. I think there are some of the most serious cases that come before the medical board, and we're looking to deal with them in the most appropriate way, which in many cases will have to be revocation. So I hear what you're saying, and I know that we are actively working with the Attorney General's office to review the entire issue of sanctions in these types of cases.
I appreciate that. I agree with you that sometimes I wonder, why are we putting on probation? We should just revoke their license. And I realize that there's challenges for you, as you've explained, to necessarily go down that path entirely, but I appreciate your commitment to continue to be sure that the medical board not only, of course, protects individual patients, but protects all of us in California in public health, especially as we're trying to end this pandemic. Thank you.
Thank you, Senator Pan. Let me, and we've referenced these disciplinary guidelines, and I actually looked at them, and it appears that the board has issued disciplinary guidelines in the form of regulations that are actually set out in our California Code of Regulations. And it appears that you've also published a manual for model disciplinary orders and disciplinary guidelines. And in reviewing this manual, I noted a few statements that I thought were significant. One is in the preamble, these guidelines set forth the discipline the board finds appropriate and necessary for the identified violations, and there are violations that are specified in the manual, general classifications. And then there's the further statement, in addition to protecting the public, and we're not inconsistent, rehabilitating the licensee, the board finds that imposition of the discipline set forth in the guidelines will promote uniformity, certainty, and fairness and deterrence, and in turn, further public protection. With respect to, we've been talking about deviations from the guidelines, at least in terms of questions from my colleagues, and the manual provides any proposed decision or settlement that departs from the disciplinary guidelines shall identify the departures and the facts supporting the departure. So my question to you is this: in what percentage of the cases where stipulated settlement was used were the guidelines followed? Anyone?
Senator, this is a question that we have looked at in some detail from time to time. The settlements all depend on the facts of individual cases, as we indicated. The guidelines are based on the supposition that all parts of the case have been proven to a clear and convincing standard, and they simply do not, they cannot apply in all circumstances to all cases. The settlements or the guidelines also generally have a range of sanctions. So we don't keep records in terms of percentage deviation from the guidelines in the context of every particular case. In order to do that, we would have to rebuild sort of a database, and it would be quite difficult to do.
Well, I'd be interested in the answer to that question. So you can add this to my list of questions and information that I'd like for you to provide to the committees through the respective chief consultants, and that is looking back over the last year, whether it's calendar or fiscal, however you compile your records. I'd like to have the answer to that question, and what percentage of those cases, those stipulated settlement cases, were the guidelines followed. So let me ask another question. In those cases where the stipulated settlement deviated from the disciplinary guidelines that are published in the California Code of Regulations, do your written records, do the board's written records identify the guideline departure and the facts and the rationale supporting the departure as required by the regulations?
Senator Roth, if I may answer that.
Yes.
The proposed decisions do contain the rationale, or they should, for deviation from the guidelines. That's part of what the board members look for when they're reviewing a proposed decision and determining whether the discipline imposed is appropriate. For proposed stipulations, the reasons for deviation from the guidelines are contained in the memo from the Deputy Attorney General.
Which I assume is privileged.
Yes, it is. And
okay,
that's because...
Well, I understand. Let's focus on unprivileged documentation. And I was focused on stipulated settlements that are approved. What would be the record that identifies the departure and the facts and rationale supporting the departure? Would that be an actual board decision?
The stipulation itself that is published does not contain a discussion on the reasons why the stipulation was agreed to and why deviation from the guidelines were appropriate. Those reasons are confidential, part of the negotiation process, and it would not be appropriate for that to be contained in a public document.
Well, that's sort of contrary to the manual that the board has published.
Well, the board does get the reasons for deviation in the Deputy Attorney General guideline, in the Deputy Attorney General memo. That must be included in their recommendation.
So if I did a records request or issued a subpoena, what document, unprivileged document, would I be requesting, having redacted personal identifying information, of course? What document would I request that would give me the reasons why the guidelines were deviated from it in any particular case? Is that
We
question?
could give you the preamble to the guidelines, gives reasons why
No, my
departure.
question, part of the problem with complainants, part of the issues that continue to be brought to this body, the Assembly and the Senate and these committees, is that people can't figure out the why. And it doesn't necessarily need to lead to identifying particular physicians who unfortunately happen to be before your board, but we're trying to figure out the why. So my question is, what document would I request in the possession of the medical board that would tell me in any given disciplinary case where stipulated settlement was used, and the guidelines were deviated from, what the reasons for the deviation were? Does one exist?
Well, Senator Roth, yeah, there would be attorney work product, the Deputy Attorney General memo itself.
But I can't access that unless somebody waives the attorney-client privilege. So absent a waiver of the attorney-client privilege, what document would, let's say, the legislature be able to look at to determine in cases where stipulated settlement as a disciplinary process was utilized and where guidelines were deviated from, the reasons for the deviation? Is there
that information
Chair Ross,
is...
it's Christina Lawson, may I answer that question?
Yes, please. I'm looking for an answer.
Thank you. I mean, the answer is that information is not publicly available, right? And maybe it's helpful for me to explain why that information is not publicly available.
Listen, I completely understand. I completely understand the confidentiality and physicians and all of that. My concern is what we're looking at here, and what I'm going to be questioning the folks about next, is the efficacy of the disciplinary process and whether discipline imposed is effective. And we didn't publish disciplinary guidelines. The medical board published disciplinary guidelines and did more than that, put them in the California Code of Regulations and a manual that you publish. So somebody needs to take a look at consistency between the imposition of discipline and the disciplinary guidelines and evaluate deviations from the guidelines, and in some cases, without getting into the personal identifying information, the why. And that's the reason why, I mean, we presume regularity here, believe it or not, despite the tenor of some of our questions, but that's what I'm trying to get at. And so let me just move on. Can someone tell me what the range of, maybe this has been answered, the range of possible discipline is in a physician misconduct case? I mean, public reprimand is somewhere in there, and then it goes to what?
Well, I mean, if you start with the most significant sanction, that is revocation. And then if you go down, and if you're revoked, you cannot practice medicine in the state of California. Then you have suspension, where you can't practice for a certain period of time. And then you have probation with conditions. And the conditions can be anything from a range of a prohibition to certain kinds of practice, to needs for chemical monitoring, for a practice monitor, for supervision. Other conditions may be less onerous, such as the taking of a course or a means of study. Then you go to a public reprimand, which is simply a public reprimand, and there may be conditions attached there in terms of training or courses. And then there's something called a warning letter, and no one really knows what that is, but it's not binding, and it's more advisory. So there is a spectrum within there, and it goes from warning letters at the lowest one up to revocation.
And with respect to probation, with or without conditions, if an individual, and this may have been referenced previously too, in which case I apologize, if an individual violates the probation with or without conditions, what's the sanction? Do you have to go back to the front of the line and go through the complaint process again, or is there something that automatically happens?
Well, I mean, in certain circumstances, if they violate probation, and probation was done in substitution for revocation, it can result in revocation.
Right, but that's where you have a discipline that's a suspended revocation with a probation, correct?
Correct.
What happens if there's no suspension or revocation and the discipline imposed is simply probation with or without conditions? What happens if there's a violation of probation?
If I may.
Yes, ma'am.
That is where the type of departure from the probation term would be identified, and it may be a citation, it may be a cease practice order, or it could go forward for a petition to revoke.
Now, cease practice order, is that a temporary order that depends on some follow-up disciplinary proceeding?
The cease practice order is, it is a temporary to determine if someone has let's say they take a bodily fluid test and it comes back positive. There are certain terms that are required to be able to have that cease practice order lifted. But again, it all turns on what the non-compliance issue was.
Well, it sounds like with a cease practice order, that's a temporary order pending the initiation of a further disciplinary proceeding against the physician involved. Is that correct?
Yes, I believe that's an easy way to describe it.
Okay.
May I provide further information, Senator Roth?
Yes.
So a cease practice order may be used if there's an initial positive result on a biological fluid test, but then those results, the lab has to provide legally defensible results. And so it could be that if it comes back negative after further testing, then that cease practice order is lifted, but it's initially imposed right away when a positive test is returned.
Well, what about something that's not a substance abuse situation? Other physician misconduct where probation with or without conditions is imposed without a suspended revocation or a suspended suspension, stayed suspension.
Probation, the way it's worded, it's revocation stayed with a certain period of time for probation.
Is that always the case?
That's, as far as I'm aware, that is always how it's worded.
Okay.
And so another way a cease practice order may be issued is if the person is required to have a practice monitor and they haven't gotten one in time, then a cease practice order will be put in place until they secure an appropriate practice monitor. If they're required to go for a clinical evaluation or obtain a psychological evaluation, and they don't do it within the prescribed period of time, the board will pose a cease practice order until they are in compliance.
And once again, once you have a monitor in that case that you've just referenced, if the individual engages in a violation of the probation, I just want to make sure I'm clear. In every case where an individual is placed on probation, there is a stayed revocation that is tied to that probation?
Yes, sir.
Okay. With respect to the public reprimand, your manual talks about it being issued for minor violations or simple departures. Is that your understanding of the use of the public reprimand?
I can assist with that also. it should be used for minor violations. The disciplinary guidelines do allow for use of a public letter of reprimand in cases of gross negligence involving one patient.
With two simple departures, right?
It could be a situation with an act of gross negligence with one patient. So it's an event that doesn't demonstrate that there's a pattern of behavior demonstrating that this person is unfit for practice and needs continuous monitoring.
And in the disciplinary guidelines, in fact, with respect to unprofessional conduct, that's the only note that I saw where public reprimand is authorized in appropriate circumstances with one patient, correct? I don't see it for dishonesty. I don't see it procuring license for fraud, excessive use of alcohol, excessive prescribing. It's just under the category general unprofessional conduct, gross negligent, repeated negligent acts, incompetence, and failure to maintain records, correct?
Well, that is true with regarding the ranges where you assume that all of the allegations are proven. Now you're getting into the area of discretion and what is necessary for public protection and rehabilitation when it's not inconsistent with providing public protection.
Well, let me just make sure I understand. In the case of stipulated settlements, those are cases where agreed to, where the physician admits to the allegation or the accusation and agrees to the penalty in the stipulated settlement, correct?
That is not always the case, and usually what they're admitting to is that if the matter were to go to hearing, the board may be able to prove the allegations by the clear and convincing evidence, may be able to. Not that they're agreeing that would happen. They're not agreeing that they committed the violations, and there's still a lot up in the air. And sometimes what's at issue is that there's a concern that the board may only be able to prove one simple negligent act. And if the case were to go to hearing and that was the finding, then the administrative law judge would propose a dismissal, and there wouldn't be grounds to overturn that dismissal. Well, so the board is weighing, in many cases, whether a stipulated settlement is supportive of public protection because the risk of going to hearing may be a dismissal, in which case there would be no report to the public on the physician's profile, or risk that the discipline could be less than what was ultimately negotiated.
Well, I think that's one of the concerns of some of us, in that the focus tends to be to dispose of the matter with the least risk to someone, the board, the risk of loss at an administrative hearing, or the other reasons that you've identified, and in some cases, perhaps, given the number of complaints, 300 and something that have moved forward to formal discipline, and the limited number of cases that are actually taken to trial, that perhaps that needs to be evaluated. But let me ask a question. In those cases, stipulated settlement cases in this last fiscal year, 2019 to 20, and I think someone indicated about 281, what percentage of those cases involved public reprimand as a penalty? Do you know?
I think we're looking for the information at the moment, Senator.
It's on the stats. Last year, there were 108 public reprimands.
Okay, good.
You say there were 108?
Yes, sir.
And that's what percentage out of the total number of cases? Well, I'll continue. You know, obviously, one of the issues that my colleagues have and concerns that they have and concerns that have been addressed to us in letters to these committees is that the board doesn't follow its own disciplinary guidelines. And I completely understand that each case has facts of its own, and there are a variety of issues that the board and the panels have to take into consideration in determining the penalty to be imposed, including evidentiary issues should the matter proceed forward to trial or hearing and a variety of other factors. Simply, it's complex. I was able to review sort of an informal summary of about 100 cases of the boards where I understand a stipulated settlement was arrived at. Cases that were resolved in this fashion between January 1 and December 31 of 2020, a 12-month period. And by my count, public reprimand for minor violations was imposed in about 40% of those cases. Does that, I know I don't want to force you to do math in public because I can't, but does that figure sound about right?
Based on the numbers I'm looking at for 1920, I would say it would be closer to 25% off the top of my head.
Okay. Well, I want to walk through a few of the cases that, at least based on the information that I have, which I admit is not your information, so we'll have to figure out at the end of this how we get more of your information and less of the information that I have. But before I proceed, I want to say this. As I've said before, I recognize that this disciplinary process is complex and it's not a one-size-fits-all situation. I do appreciate the hard work that the medical board and the board members do every day to attempt to protect the public in this particular area of regulation and licensure, and frankly, the simply extraordinary work that the overwhelming number of healthcare providers, specifically including physicians, put it forth and perform around the state every day, particularly in this pandemic. But let me talk to you about a few cases, and then I'll wrap this thing up. Case number one, for example, physician admits to using the identity of transient patients to secure drugs and self-prescribe, resulting in a criminal conviction. Now, assuming those are the facts, you have the records, looking at the guidelines and categories of various offenses, I assume this could be dishonesty arising from patient care, could be a conviction of a crime, could be a violation of drug statutes, or frankly, general unprofessional conduct, any of which, as I read the guidelines, carry a minimum penalty in the case of dishonesty and conviction of a crime, stayed revocation, a 1-year suspension, and at least 7 years probation. And in the case of some of these other offenses that I've listed, a stayed revocation and a probation period of 5 to 7 years. The records I received reflect only a 7-year probation was imposed. Now, I believe I understood previous testimony to indicate that in addition to that 7-year probation, there was a stayed revocation.
Senator Roth, that is the typical way that orders for probation are worded. Stayed revocation with the period of probation following.
Is that ever deviated from in the case of probation and stayed revocation? Specifically, I've asked before, let me just make sure, I want to ask it again. Are there cases where probation is imposed as a penalty without any stayed revocation or suspension?
I cannot think of an example where that wording was not used, but I can't say that it's never happened.
Okay. Here's another case. Physician convicted of domestic violence in the state of Florida failed to report that conviction as required to the medical board. Now, I look at the guidelines, and that seems to specify a 5 to 7 year probationary period, and in some cases, state revocation. But the records I reviewed reflect that the physician received a public reprimand. Now, I realize you have your records, and I don't know about the material that I received, but given the fact situation that I presented, would you consider that to be a minor offense or a simple departure? Anyone?
Senator Roth, it's difficult to respond to these scenarios just based on that information. The board would not consider that to be a minor offense. The issue is what is the evidence surrounding it that the board had access to, what is necessary for consumer protection and rehabilitation of the licensee, and whether this is a situation where continuous monitoring is required. The board doesn't have authority to punish physicians, and if the board goes beyond what is necessary for public protection, then the board anticipates the physician would seek judicial review, and the matter would come back to the board to review the penalty again. And so that's kind of surrounding information, but I am not comfortable speaking to a particular case based on a line of information.
Well, here's another one. Physician convicted and subsequently lied to the medical board about the conviction. Penalty imposed, public reprimand. Yeah, I realize you can't comment on some of these, and I may not have the facts exactly right, but I guess the point is there's concern about the use of the very least penalty in some of these cases, where the offenses would seem to go to the very nature of the physician's obligation, integrity, honesty,
right,
among other things. Here's another one.
I'd like to,
okay,
may I respond to that,
absolutely,
Senator? Because I think this brings up a good point, especially in light of AB 2138, where the legislature now tells the board that the board can't deny a license if a physician is not forthcoming on information that wouldn't by itself be grounds for denial. The board no longer asks for disclosure of convictions following that piece of legislation. The legislature expects the board to consider evidence of rehabilitation, and under 2138, if the physician has successfully been able to have a conviction expunged, the board is not to use that as grounds for denial.
Well, but you're ignoring the fact that the discipline and the penalties that you have designed and built into your guidelines and your manual are a sliding scale, and there's a long road to walk or drive between a public reprimand for minor offenses and revocation at the tail end. So I'm just concerned that this is a black and white issue for the medical board, and it's either X or Y, and there's no room in between. Here's another one. Physician convicted of domestic violence act apparently causing significant injuries to the victim. The guidelines would typically call for a minimum penalty, by the way, of state revocation and a 5 to 7 year probation. And again, the information that I was provided indicates a 5-year probation was the penalty. No reference to a state revocation, but if you follow what you've indicated before, perhaps that was part of the process. I'll just go through these quickly. I don't want to belabor it because Physician's practice resulted in the deaths of 2 patients with the records reflecting an earlier death of a 3rd patient and admitted multiple extreme departures. So in this particular case, there was 7-year probation, no reference of a stayed revocation or suspension, at least in the records that I have. Another one.
Senator Roth, are you actually looking at a decision from the board or a summary that someone not board staff presented to you?
Well, I'm looking at a summary that was prepared. I don't have board decisions, and of course, that's our problem, and I'll get to that in a minute. Physician convicted of battery upon his or her partner, okay, convicted. Physician received a public reprimand. Public reprimand. Here's another one. Physician convicted of an assault with a deadly weapon. Doctor had a prior conviction for animal cruelty. Probation was imposed, despite the fact that the guidelines would tend to suggest as a minimum penalty something more severe. And one final one, I think, and then I'll close. Obviously, there are more. Physician apparently failed to file a Child Protective Services report of abuse. In a known abuse case, young child was subsequently abused further and died. One or more of your experts, someone's expert, concluded that there was an extreme departure, and the penalty in this particular case was a public reprimand. So, you know, this is not an I gotcha situation. I may not have all the facts. Obviously, you have them. And there are more of these that have been suggested. The point is that there appear to be a variety of cases where lesser penalties have been imposed, where the guidelines suggest that more serious penalties at least be considered, if not opposed, as a method of corrective action, short of revocation, as a method of corrective action and rehabilitation. So I guess 2 questions. How do you suggest we address these actual or perceived issues? Certainly issues perhaps of the nature of the penalty imposed, but certainly transparency. And are there changes in this process that we need to consider here to make the disciplinary process make more sense to us and transparent, perhaps with reports redacted as to personal identifying information, so we can evaluate how the board is disciplining physicians that you are supposed to regulate, license, and control in the sense of performance, quality, misconduct. Thoughts?
Senator, if I could interject there, this is a problem that has been confounding jurisdictions in many places, I can assure you of that. The difficulty that we have here is that there is a need to have a settlement process. The medical board, frankly, has simply run out of money. We are not on a financially sustainable basis, and we need to find efficient ways of dealing with cases. For reasons that have been explained, the settlement process by its very nature is confidential for reasons that have been explained. What therefore we need to consider, along the lines of what you have suggested, is a more transparent manner of setting forth how these settlements are based, what goes into them, and perhaps it means issuing revised guidelines, issuing more complex guidelines, issuing reports where cases are anonymized, but to explain better the range of sanctions and the factors that go into them. The difficulty that we face is that given the mountain of cases that we have to deal with, is that the settlements remain a very important component of it. But I take your point that we need to come up with a more transparent way of explaining how these cases are resolved, what factors go into them, and the benefits that are achieved by doing it this way. For those of us who are involved in these cases on a daily basis, we know that by resolving them quickly, by getting sometimes very strict undertakings, I understand the cases that you have selected are done for, they fit into a certain pattern. We could select other cases where the stipulations have been very severe. But that's not the point. They go into a range because the cases require that they go into a range. But I certainly take your point that we need to have more transparency in the very complex factors that go into it. And I think the medical board needs to make a stronger case on how retaining these types of systems are in the public interest. But for example, if you look at the current processes by which these stipulated settlements are arrived at and are approved, there is board oversight of it. Now, maybe we can look at improved oversight or a different form of oversight, but that does exist. It does exist now, and I've seen it work. But I take your point that we need to think of more transparent ways of explaining what is a very complicated, very legalistic process.
Well, thank you. And listen, I want to thank all of you for your participation and your attempt to respond to some very, very difficult questions by some of us who were probably being very difficult at the time we asked them. One of the things you can add to my list of questions I'd like to see in response is the number of cases of probation violation where licenses were revoked in the case of a state revocation versus the number where licenses were not revoked in the case of a probation violation. So again, thank you all. If you can stay on, there may be further questions. I think we need to move to our next panel at this point. It's the overview of patient impacts. We are fortunate to have with us Bridget Graham, Administrative Director, Supervising Attorney, Center for Public Interest Law, and TJ Watkins, a current medical board member, to present. Thank you, both of you, for your patience in listening to the rest of us drone on and for waiting for your time to present. So, is it Ms. Graham?
Yes, thank you. It's Grammy, actually.
It's what, excuse me?
Grammy.
Grammy. I apologize.
Yes.
I hate to mispronounce people's name.
No problem. It happens. So good morning, as I mentioned, or good afternoon, I should say now. My name is Bridget Grammy, and I'm the Administrative Director of the Center for Public Interest Law at the University of San Diego School of Law. And I want to thank the committees for inviting me to comment today and for the tremendous amount of time and effort that your staff have put into the very impressive background paper prepared for you. I also really appreciate just listening the very thoughtful and thorough questions that you all have raised this morning. And it really shows that you're taking this very important oversight role seriously. And I hope that our recommendations will be useful to you throughout this sunset review process. For those of you who are unfamiliar with CPIL, we are a nonprofit, nonpartisan academic and advocacy organization based at the University of San Diego School of Law. For over 40 years, CPIL has studied occupational licensing and monitored California agencies that regulate business professions and trades, including the medical board and other DCA healthcare boards. In 2003, my predecessor, Julie D'Angelo Felmuth, was appointed by the legislature to serve as the board's enforcement monitor after continued reports of problems with the board's enforcement process. After 2 years of study, she made 65 recommendations, many of which have been adopted in a series of reform legislation. CPIL continues to monitor California's major regulatory agencies and publishes the California Regulatory Law Reporter, which tracks agency activity. The title of this hearing poses an important question. Does the medical board protect the public or physicians? It is not a question that can be answered with a simple yes or no. And so during this sunset review process, I urge you to ask yourself a slightly different question, which is, does the public believe that the board is prioritizing public protection over protection of physicians? And as I expect you will hear during today's public comment, and as Ms. Lawson alluded to in her comments earlier this morning, the answer to that question right now is no. I really appreciate this morning's discussion about the board's ability to be proactive in its regulation. To be fair, the board is not set up right now to be a proactive regulator. The current discipline system is in fact a complaint-driven system. And as we raised in our letter, this is a very important issue that the legislature should consider changing during the sunset review process. We should not have to wait for patients to be harmed before the board can start taking action. From a purely objective standpoint, the case processing times from complaint to resolution right now are simply unacceptable. Let's not forget that in both of the tragic and specific cases that you discussed this morning from Chairman Lowe's district and from Senator Hurtado and Assemblymember Fong's district, those physicians are still practicing medicine right now as they move through the discipline process. As attorneys, we understand and appreciate that accused physicians are entitled to due process in any proceeding that may impact their continued ability to practice medicine. This is an important right and preserves the integrity of the system. But in our observation, as we have pointed out in our letter, this right can be abused by physicians and their attorneys who use an array of stall tactics to drag out the process as long as possible, often for years, at great risk to the public. An appropriate balance must be implemented. With respect to the public trust issue, the board survey results indicate that the public's experience with the complaint process is dismal, with the vast majority of responses labeling their experience as poor or very poor. We have heard stories of patient advocates whose cases were closed without ever being interviewed by anyone at the board. And again, as attorneys, we understand that the board can only proceed on a complaint if it has a statutory basis to do so. But the procedures as they exist are devaluing the often traumatic experiences that these complainants have endured, and they're continuing to break down the relationship between the public and the board. And I think several of the questions that were asked today of the board really reflect that. Bringing to bear our 40 years of experience in monitoring California regulatory boards and our advocacy over the years to hold these boards accountable to protect the public and not the profession, I will focus my comments today on 4 key recommendations that will enhance the board's ability to ensure that public protection remains its paramount priority, and it's more fully detailed in our written testimony that we submitted. The number 1 is the board's fees must be increased. I realize this is not the focus of today's hearing, but it is very relevant to the board's ability to establish and maintain a robust enforcement system. They have not been increased since 2006, and the board has more than justified its need to increase its fees. This is critical for the board to accomplish its mission of public protection. And the fact that the executive director was just telling you that they are not in a financially sustainable position and appear to be motivated to settle cases in order to save money is extremely concerning. The second recommendation we have is that the legislature should add 2 public members to the board. CPIL has been advocating for a public member majority of the board for decades. And importantly, Senate President Pro Tem Tony Atkins raised this suggestion a few weeks ago at the Senate Rules Committee hearing after a number of patient advocates raised serious concerns about the board's ability to protect the public. We completely agree with staff's observation that establishing a public majority on the board would decrease the risk of antitrust exposure and have value added of a more patient-centric board. As I explained in more detail in my letter, it has now been 6 years since the U.S. Supreme Court issued its opinion in North Carolina State Board of Dental Examiners versus the Federal Trade Commission. That landmark case held that boards that are controlled by active market participants in the profession regulated, such as the medical board, which is controlled by doctors, are not automatically granted immunity from the antitrust laws just because they are a state agency. And regulatory boards make decisions every day, such as who may enter the profession, that if done in the private sector are unquestionably anti-competitive. The Supreme Court laid out a series of checks that must be present to show that a board is sufficiently and actively supervised by the state in order to enjoy state action immunity from the antitrust laws. And those checks are not present right now here in California. In fact, CPIL sponsored a bill that would authorize DCA to exercise additional supervision over its semi-autonomous boards, but that legislation was unsuccessful after heavy opposition from trade associations. So increasing the number of public members on the board would certainly help to ensure that the public remains a key focus of the board's activity and would lessen the opportunity for the profession to control the board. And I would add, as I added in my letter, there are 3 public member vacancies right now, which are just exacerbating this problem. Third, we recommend that the legislature should appoint another enforcement monitor. And based on all of the questions today, it is clear that the board's existing enforcement system is a matter of great concern. It is under-resourced. It appears that there's been a breakdown in the relationship between the Attorney General's office. The transfer of investigators to DCA in 2013 created further problems, and the public trust in the board is extremely low. And what is less clear is what to do about it. The board's ability to quickly and efficiently identify and remove harmful doctors from practice is literally, as you will hear during public comment, a matter of life and death. Resolving this very, very serious situation through the political process, where the parties whose interests are at stake are less than objective and have unequal levels of influence with decision makers, is not the way to do this. Serious reform of the discipline system must be based on evidence, gathered and analyzed by an independent researcher. Such an objective study benefits everyone. For physicians and patients, it makes sense to have a vigorous, trusted regulatory program in place that prevents as many patients as possible from being damaged in the first place. Among other issues, the enforcement monitor can conduct a thorough and independent study of the instances in which the board deviates from the disciplinary guidelines, for example. They could take a closer look at the efficacy of the probation monitoring program, assess whether the public protection is at risk through these issues, and recommend amendments to the guidelines and procedures involving settlements. The monitor could also research and recommend proactive regulatory approaches, as we talked about earlier. In addition to this existing complaint-based model that would permit the board to identify and discipline potentially harmful physicians before patients are harmed, rather than wait for them to be harmed and then file a complaint. As I mentioned earlier, this is an approach that we are recommending at multiple boards, including the State Bar of California. And based on the questions of the members this morning, it appears that this is something the legislature might be interested in exploring as well. Regardless of whether you decide to appoint enforcement monitor, the following critical issues must be considered during the sunset review, as the background paper so helpfully points out. And I'm just going to highlight a few because I know we are really running low on time. But one thing that hasn't been brought up very much today is the investigation process. And I would like to reiterate CPIL's recommendation that the board's investigators should move back to the Attorney General's office as originally recommended by the enforcement monitor, so that all of the team members, prosecutors and investigators, can work together as expeditiously as possible to maintain consumer protection through vertical enforcement. This recommendation was never implemented as recommended and was only made more complicated by the transfer of the investigators to DCA. The board's data makes clear that it was the transfer to DCA and not vertical enforcement that is responsible for the unacceptably high investigation times. At a minimum, the legislature should consider reverting to the investigators are employed by the board, and the Attorney General assigns a deputy and district office to work in each MBC field office to provide legal assistance and guidance to investigators. We do not support the suggestion in the background paper that the legislature consider permitting the board to investigate and prosecute its own cases at this time. With all due respect, this would only exacerbate the public trust issue and should not be considered until research could be conducted that would support such a departure from Attorney General prosecution. I also want to highlight quickly the mandatory reporting requirements in issue number 15. It's very concerning that the board suspects it's not receiving many of these mandatory reports. And these are critical tools that will lead to identification of discipline of harmful physicians. And as Senator Roth mentioned as well, the fact that that one particular case in Santa Clara in which this physician was permitted to practice for many years despite many complaints and findings from other state agencies, it raises questions as to this mandatory reporting requirement and whether we need to include additional mandated reports for state agencies. I do want to highlight too that we pointed out in our letter, there is a mandated reporting requirement for settlements up to $29,900, or for settlements of $30,000. And we have been aware of what we are suspecting might be a widespread practice in which people are settling cases for their insurance companies to pay $29,999, and then they pay out of pocket the difference to the plaintiffs. And this is a way that they are avoiding having to report these settlements, especially insurance companies having to report settlements. And I believe this is a really important thing that needs to be investigated further, and perhaps we should just eliminate the $30,000 threshold and all settlements should be reported to the board. And then issue number 20 on probation disclosure, particularly with respect to the physician that is in Senator Hurtado's district, that person was placed on probation for gross negligence. And I just wanted to point out that the existing Patients' Right to Know Act and the requirements for physicians to disclose to their patients if they're on probation would not apply to that doctor because currently gross negligence is not one of the statutory requirements for disclosure. So this is something I think it exposes a real gaping hole in the system, and I think that we should be expanding the Patients' Right to Know Act and enhancing the transparency. My final recommendation has to do with an independent ombuds office. And this idea is coming from looking at other jurisdictions, including the UK, in which an independent office would be established to help complainants to navigate the system, to facilitate this, to help them explain what's going on with the process, and also to identify possible trends that may be currently not a violation of the Business and Professions Code, but perhaps should be, and at a minimum could help assist the board with proactive regulation. So I really appreciate the opportunity to speak to you today. I'm happy to answer any questions, and CPIL is available to assist the committee and its staff as they work through the sunset review process. Thank you very much.
Thank you, Ms. Grammy. We appreciate your comments and your recommendations. You'll be with us for a few minutes anyway, I assume. Let's move on to Board Member Watkins, if you're on the screen or on the line. Mr. Watkins?
Hey, good afternoon, Honorable Chair Roth and Honorable Evan Lowe, and to the committee. And I'm very grateful to be able to speak in this hearing. First, I need to thank someone on this committee, because last week around this time, I was pulling my hair out in frustration. And that has happened a lot in my time on the board. And Assemblyman Evan Lowe was talking to the executive officer of the BRN, and he pointed out that public members can't speak in this forum. And yes, the day before, I was just so down, because the issues that I have raised in this board has gone unheard. And when I say unheard, I'm saying that people are nice and they will smile at you, but they will do nothing. And that has been troubling. And I lost faith that in this forum, this board forum, the actual problems and challenges that exist can be solved in this forum. And I will articulate this as I continue. So thank you. So just a little background on me. My name is TJ Watkins, Ezra TJ Watkins. I'm from South Africa. I was appointed to this board in June of 2019. And prior to that, I served on the physical therapy board for 3.5 years. Ended up being the vice chair and also a delegate to the Federal States Board for Physical Therapists. And during that time, I've had extensive training in the role of a board member, how to adjudicate over alcohol cases, alcohol use disorders, gross negligence, and all of these things. And the 80% stays the same when you come to the medical board. And then there's a big layer of legal stuff that you have to learn. And time again, when I came across cases that was troubling from a public protection point of view, and I raised my hand and I brought it before someone, a legal veil was dropped. And it was, you do not understand. You're a public member, you do not understand. Board counsel, she was always nice to help me understand. And that gave me the education I needed to actually go in and really look at these cases. Because the funny thing about these cases is that they really involve people. When they involve people, there is an energy attached to it. So that's my backdrop. Why does this board even exist? I've heard that question so many times. Why do, when people hear you on the medical board, why do they exist? They do nothing. Or they just take licenses. I've heard that as well. So there's different varying perceptions. But I would like to quote the basis on which this board is founded, and that is Business and Professions Codes 2000 subsection 2001.1. Speaks to the priority of the board, protection of the public. Protection of the public shall be the highest priority for the Medical Board of California in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. The protection of the public shall be paramount. So now today, as part of my continual education, I hear the executive officer point to Business and Professions Codes 2229, in which he says that public protection is one thing, and then there's rehabilitation and the practice restrictions. Business Code 2001 says, if there's any other competing interest, this shall be paramount. But during this period, I had a whole a lot of notes that I wanted to present, but I don't need to anymore because points have been made. And so what I want to explain and clarify, that it became clear for me so I can sleep tonight, is that there's two worlds that we are seeing. We're seeing the world in which you live as a board member and the board staff and all of this. And by the way, the board staff does incredible work. They work really hard. It's we as the board members, when we make these decisions, that fail all of them, including the public. We undermine the staff's work and we undermine the board experts by the decisions that we make. And it's most troubling to sit on a board and have your professional integrity challenged every single time. Every single time, you gotta step over whatever your values are. This board's values, and values being defined as what you do most naturally without thinking. This board's value is we protect the doctors. And we'll go over and above in order to do so. More accurately, Business and Professions Codes 2229 gave me insight because rehabilitation in the Medical Board of California is seen as the key to reduce sentences. It's the key to anything. And when you actually apply the guidelines, it is perceived as punishment. But we wrote the law. The only reason why any of these cases that is so troubling comes before this board and are decided by the board, we as the board members, me included, we are responsible for those decisions. We do not push back to the executive officer enough when we come across legal advice that is bordering on it's biased, it's misleading, it is fraught with omissions and commissions, and it reads like a defense for the doctors. It's troubling. A lot of the pain that the public is experiencing is contained in those documents. And it's troubling on every level to sit on this board and to try. I have a positive, forward-looking attitude. I go through life and I am a problem solver. What I do for my day job is I look for patterns, and the patterns jumped out at me in this board. Why do I say that this board protects doctors? Because it sounds inflammatory. But I'm gonna quote statistics because I've been shut down so many times by trying the good way the right way to do things, that I've decided for the whole of last year, every case, every stipulated settlement that comes across my desk, I'm going to track whether we follow the guidelines, what is the probationary period that we're going to impose on it. What has been troubling in the background, paper, and everything, and I apologize for everything being troubling. It's just interesting. Let's change the word. The board uses a legal veil to protect doctors. And we know now that rehabilitation is on top, and then public interest somewhere follows at the lower levels. That we know. We know that from the statistics. And let me bring you some of the statistics. Every case I did, me personally, gave a decision on last year, and what's the outcome of that decision, I have tracked. It's my personal information. I'm not sharing that information with anybody, but it's interesting how closely it resembles the top line numbers within this board. I want to go through them quickly. But before I do that, something popped out at me. A question was asked about the board member composition, and nobody from the board, no one answered it. We were saying there were 7 authorized members of the board. We were saying, yeah, there were 6 members of the board. So let me just clear that, because it's a small thing, but it's a symptom of a bigger problem, and a problem that is consistent. It's a little omission, right? So let me give you the facts about what that looks like, because while this was happening, I went to go look for those numbers. And in 2013, there was 6 doctor members on this board when they appeared before this committee, and there were 4 public members, a doctor majority board. In 2016, so the following year after the next sunset review, there was 8 doctors and 6 members. And now, this year, at sunset review, there are 8 members, doctor members, and there were 4 members up to the last board meeting. They just appointed another one. There's an interesting implication with that. Both panels are set up in a way that there's a majority of doctor members. And so if a decision that came from the DAG and our executive officer falls out of the guidelines, or we are unhappy as public members, we simply do not have the votes. We simply do not have the votes to override that. And we have in the past. We have done that successfully. So I don't say it cannot be done. And I will speak to this point a little later again. But first I want to introduce you to the statistics. What did I find? And I'm so confident that when you extrapolate these numbers, that you will get within 5 or 7% of what I'm going to quote here today. And some of it is going to seem far out, and I'm setting the stage for it because it's pretty disturbing. So let's talk about the executive officer using in the background paper first, that we settled 79.5% of our cases, but last year we did 84%. And yeah, it's normal. Everybody does it, is what I kept hearing. Everybody does it. Oh, this is a normal standard within this community. Yes, it is. Unfortunately, that may be true, but it's how we do it. And in the how, we find everything. If we were settling those cases, following the guidelines, I would not be sitting here. If we were settling these cases with appropriate real rehabilitative initiatives in place, I would not be sitting here. But I'm sitting here because none of that is followed. It's as haphazard as anything from my experience. My board members may disagree. So let me quote you this. And this is also a theme. The callousness, like indifference with which these numbers are represented is even so much more troubling, because I want to give you a sketch of the background of this. When you enter into a stipulated settlement, the doctor walks away without having to incur any more issues, regardless of how egregious the offense, right? And the victims or the public that has been affected by the behavior of that doctor, they'll be lucky if they get a letter. And they are left having their due process cut short because now we want to save money. Now we want to go efficient over being effective. And that shows you that this system is not designed to protect the public. It is because who benefits, right? But let me bring you into the real feeling stage, the stuff that we kind of avoid. But it came home to roost at our last board meeting when folks called in from this place, Bakersfield. I've only driven past it. And the heart fell, the heartbreak of not having answers. The cry of a mother who lost her daughter. The cry of a father who's feeling powerless. Powerless because he couldn't protect his family. We created that. No one else. Our board panels that makes these decisions, we can easily push back. We can review cases. If we wanted it so, it will be so. Because eventually, all the cases come back to us. And when they come back to us, they come back with comments so we could get better. We could build the system better if we wanted to. But there's no will, there's no creativity that I have witnessed. But what there is concealing, a closed system, shutting everybody down. That's what it is. So let's continue. So out of that 79.5% of the cases that everyone does it, let me give you my statistics. Out of all my cases that I did last year, and this may interest Chairman Roth, that for the stipulated settlements, that we deviated 90% of the time using, in my opinion, weak mitigating factors, misrepresenting facts, and omissions and commissions. I'm going to end it there, just to not be inflammatory. But the theme is that it benefits doctors. And many times when I see this, I'm trying to think what happens in the background. So when I push back onto these cases and come to board leadership, it becomes very apparent that they will listen to me, but humor me, because we're not really going to change anything, because we have a 4-2 majority on your board. And unless I come and I prepare 3 days, 2 weeks in advance, I've learned more skills about presenting cases than I ever thought I would, so I'm very grateful for that. But here's another interesting statistics from my information that I think would be in a range with the board's information if we were to share information, if we ask for reports. Dr. Rod, Chairman Rod asked for how many times did we issue letters of public reprimand? And I have it at 40% of cases. Around 30% to 40%, that's where we are. So we settle a third or more of our cases via public reprimand. And I learned something today, that it includes 1 patient and 2 simple departures. That's not consistent with what I've seen. And I'll leave that at that too. Another point about the public reprimands, in the background paper, the board quoted, and again, a little thing, not a big thing. The board quoted that, yeah, we have 248 reprimands for 3 years. When I did that calculation for the year 17, 18, 18, 19, and 19, 20, I got 375. That's a theme. It's a theme of how we play with numbers. It's a theme when you present top-line numbers and you don't really get into the numbers. But I don't want to go too deep in that. Someone else can do that because I've done enough of that. Here's another interesting statistic, right? We settle probation cases, around 73% of all probation cases, with a letter of public reprimand, 2 years probation, 35 months probation, and 3 years probation. Our 3 years probation, we settle that at 19% of the time. So 73% of the time, we deviate 40% from the guidelines on average. So just think about that. Think what that means. That means in the rest of the time, in the other 27% of the time, that's when we follow the guidelines. And I can tell you, most of the times when we do follow the guidelines, those cases needed to be revoked. Those cases are so egregious that we needed to take a stand. But because we don't have the will to really protect the public, we can say that all day long. We can say that. It's not present in the statistics. It's not present in our behavior. And guess what? The public tells us that all the time by telling us they do not trust us as the Medical Board of California. And I kind of agree with them. We have not earned their trust. Recently, when our colleagues were before the Senate for a confirmation hearing, one of our colleagues pointed out that, their doctors pay these fees and, what I was essentially saying is that it's their board. But I want to explain something about licensing agreements because I've done a few of those in my life. A licensing agreement is that you have acquired trust in a brand. And whoever buys that brand is buying that reputation. And for many years, throughout the ages, doctors have been the premier brand in terms of public trust. Well-deserved. Well-deserved because they've always done good. But there is a very, very small percentage of doctors that deviate from that old standard. So when we do not follow the guidelines, we dilute the very integrity of the profession that we say we care about because we do not hold doctors accountable for wrongdoing at the level that we can. Now, there's many reasons for that. I could sit down with our legal counsel and we can go through sections of this law and come up with new ways to do this that will aid us. There is solutions, but we've never had this conversation. And that's why I'm appreciative. I've always ever just wanted this conversation.
Mr. Watkins, I need to give you a 1-minute warning. I apologize, but we're going to have to move on to public comment here very, very shortly because I suspect that there's a fair amount of that as well.
So I will wrap up in 40 seconds.
Okay.
The other thing that is that we do not, we say we apply the uniform standards, section 1441, and we don't. We say we undermine our experts so much that every time the 40% time that we write public reprimands, 38% of that is because there was expert issues. I'm going to just leave it at that. And in conclusion, I'm a forward-looking attitude kind of problem-solving person. That's how I come to it. But I want to invite the committee on a journey to really address the medical board's challenges, because they are integral to our society. And I want to ask of this committee that they work with us, find the right data and information, so that we can actually have real data to work from, so that we can come up with real solutions. I thank the committee. I thank everyone that made this possible. And I am confident now we would at least begin to start a dialogue in a fresh space. Thank you.
Thank you, Mr. Watkins. Let me just check to see on the computer screen if we have any questions from members of our panelists. None here in the Senate chambers. So thank you all. Thank you, members. Thank you, panelists. We will now accept testimony from members of the public regarding this Medical Board of California Sunset Review hearing. Let's begin with any witnesses in the gallery. I see no witnesses. Are there any witnesses in room 112 who wish to provide public comment? I see no such witnesses. Thank you. We will now move to the witnesses waiting to provide public comment via the teleconference service. Thank you for your patience. Moderator, if you would please prompt the individuals waiting to provide public comment about the Medical Board of California, we will begin.
Thank you. If you wish to make a comment, please press 1 and then 0 at this time.
Thank you, moderator. And before we start, once folks have queued up, would you give me an estimate of the total number of people waiting to testify?
I currently have about 20 in the queue.
Thank you. Thank you, moderator. If you would please open the lines and call the members of the public individually, we will continue.
Thank you. Line 74, please go ahead.
Chairs and members, Vanessa Kahina with QC Public Affairs on behalf of the California Academy of Family Physicians. Although it was not addressed in today's hearing, we would like to note the background speaker's discussion on issues around the postgraduate training license, which is a major concern for CAF. The committee is for a letter and discussing the piece a little later. Thank you.
Let me just comment for those on the line who are presenting testimony. It was very, very difficult to hear and understand the last presenter. I don't know if it's the phones you're on or if it's our connection, but let's try to speak slowly and clearly so that we capture all of the comments. We value each and every one of them. Next.
Thank you. Line 79, please go ahead.
Thank you, Mr. Chair and members. If it helps at all, we do hear feedback on the phone line, like an echo, but I'll try to get through my comments. Megan Subers on behalf of California Health Plus Advocates, representing the community health centers and clinics. Although not specifically discussed today, we look forward to discussing the issues surrounding the postgraduate training license at a future oversight hearing. As outlined in your committee background document, there are significant issues that have come to light during implementation of the PTL that have negatively impacted the ability for residents to provide care in communities of most need and at the over 40 community health centers that train residents. We appreciate all the time spent on the issue by the medical board staff, your committee staff, and the members, and look forward to the committee discussion and a quick resolve on these issues. Thank you.
Thank you. Just a reminder to those on the lines, please remember to mute the piece of equipment that you're watching the hearing on, whether it's a computer or something else that will cause feedback. Next.
Thank you. Line 82, please go ahead.
My name is Jill Stegman. I'm an advocate with the Fairness for Injured Patients campaign and a constituent of Assemblymember Cunningham's in Grover Beach. My husband, Don, was a cancer survivor. In 2013, when he was experiencing severe psychotic symptoms while on the drug prednisone, I contacted his doctor at Stanford Medical Clinics to ask her to evaluate Don and prescribe treatment. But Don's doctor refused to treat Don with any drugs to control his psychotic symptoms and would not refer us to a psychiatrist. She said instead that he would be fine once he was tapered off prednisone. After about 3 weeks, my worst fears were realized. Don became very depressed, and on the morning when I decided to find a psychiatrist on my own, he left home and never returned. Later, Don's body was found. He had died by a self-inflicted gunshot wound. Subsequently, I researched treatments for prednisone-induced psychiatric reactions. The majority of medical researchers stated that patients should be evaluated and closely monitored, prednisone reduced if possible, and drugs prescribed for extreme cases. Warnings were given to watch for suicidal behavior. With this information in mind, I filed a complaint against Don's doctor with the Medical Board of California, stating that she had been negligent by not evaluating and treating Don for his psychotic symptoms. To my disappointment, the board concluded that Don's doctor had acted within the standards of medical practice by simply tapering Don off the prednisone. They ignored the whole reason for my complaint, that Don's doctor had been negligent by not evaluating, monitoring, and treating Don for his psychotic symptoms caused by the prednisone. They didn't understand Don's case because they closed it without once speaking to me. It was as if the medical examiner purposely sought to exonerate Don's doctor instead of holding her accountable. Please hold the medical board more accountable to the public by making them interview every patient who submits a complaint for negligence and by increasing its public members so doctors are no longer in charge. Thank you for the opportunity to share my story.
Thank you. Next, please.
Thank you. Line 49, please go ahead.
Good afternoon. My name is Carol Bradley. Excuse me. I'm a member of the Fairness for Injured Patients Act campaign and a constituent of Senator Becker and Assembly Member Mullen in Redwood City. My husband died due to medical negligence while under the care of a physician's assistant. I filed a complaint with the California Department of Public Health, and their investigation resulted in a finding of the highest scope and severity, level 4 immediate jeopardy. The information was forwarded to the California Medical Board for review and further investigation as it related to the physician's assistant's actions. Months later, while I was deep in grief and struggling with PTSD due to the incident, I received a letter from the board. It indicated that a record of the incident would be placed in the physician assistant's file and disciplinary action would be considered only if there were additional incidents. I was appalled by the board's decision. They failed to discipline and hold the physician's assistant accountable even though there was loss of life. Justice was not served. I'm a healthcare professional, and by their inaction, the California Medical Board has lost my respect. I will forever be left with the impression that one agency viewed the incident as substandard quality of care with loss of life that required immediate correction, while the other placed it in a file. The fact that a life was lost didn't seem to matter. Sadly, the life lost was that of my beloved husband, Michael. It's clear that your first priority is to protect the practitioner and not the consumer. Please reform the board to include more members of the public. Thank you for the opportunity to provide comments today.
Thank you for taking the time to present your testimony today, ma'am. Moderator, next caller, please.
Thank you. Line 50, please go ahead.
Line 50.
Yes, please go ahead.
Good afternoon, respectful Assembly members, senators, Senator Susan Eichmann, Board Chair Christina Lawson, Howard Groth. Thank you so much for giving me opportunity to participate in today's hearing about the medical board. A few years ago, board member Dr. Sharon said that medical board is a body of law. There's been many actors and players involved, and the result of the disciplinary scheme is often a blank letter, blank page issued by the member of the medical board without any hearing, without any facts. There is no hearing scheduled before the medical board. Doctor has no right to confer adverse witness. I have spoken before, I'm just going to bring up, I have spoken before state legislature on few occasions. In 2013, my wife and I spoke with state senators. We have brought our issues before Senator Susan Eichmann and other respectable politicians in the San Joaquin County. I'm going to mention a brief event about some of the other rectors. They are working in the name of the medical board. It's San Joaquin County Hospital. It's a reputable hospital in the Central Valley, supervised by respectable county supervisors. Dr. Fazana Sheikh was a medical student in the hospital. During her residency training, she interviewed for jobs, and she accepted one of the job offers at the hospital. She had a bright career ahead of her. And after her application was made, the county hospital employee and the board employee held some undisclosed secret conversation, and they just sent an email denying license allegedly for not completing 24 years residency training. Extensive review of the evidence showed that both of those, hospital and the board, knew that she had completed 24 months residency training, and they stated alternative facts. If we can be upfront, we can say that they knowingly made false statement and they just denied license without just for saying that she has not completed 24 months residency training. Since then, everyone has been denying right to trial. It's been 12 years. It's the county employees, they are controlled by the San Joaquin County supervisors. The board employees, they can be disciplined by the board members and the state legislators. And we are disappointed that no one has taken any action to hold those employees accountable. As a result of this thing, Dr. Sheikh, she has been deprived of her right to work in very difficult circumstances. 9 months after the denial, both the county hospital and the board, again, they had undisclosed conversation. They exchanged some letters, and they say Dr. Sheikh has completed 36 months residency training, but they failed to issue the license. Instead, they took another harsh action and terminated her residency training. A sort of character attack to willful intent to damage someone's career. All the parties have been denying right to trial. We have been promised by the medical board and the Department of Justice that this is a simple matter that can be resolved in a short 4-hour trial. According to them, they suggest it only take 4 years, but this has been more than 10 years, and that 4 hours have yet to come. As a condition of license, the county hospital and the medical board and the attorney general, they issue stipulation, they initiate character attacks, meeting campaign, but they all demand confession and they all demand right to trial. Today, I am again requesting the board chair, Christina Lawson. She is a very talented attorney and respectable state senator. When will be the trial? Who is responsible for denying the trial? It's a very difficult situation. Dr. Fazana Sheikh, she trained and received certification from reputable universities such as Stanford University, University of Texas, University of California. According to medical professors and the peers, they have submitted written letters and statements clearly stating that she has been an intelligent, hardworking, and compassionate physician. She often devoted extra time to patients out of her compassion. So this is a very difficult scenario that the state legislature and the medical board members are requested to confront. When both the hospital and the board employees state alternate facts and deny right to trial, what is the mechanism that state legislature has provided? Who is responsible for active supervision? Who is responsible for the damages?
Sir, I would ask you to, let me ask you to, unfortunately, I'm going to need to ask you to wrap up. I would appreciate it if you have that in writing, if you would submit your statement to the chief consultants for both of our committees, that would be most helpful.
Yes, sir, it's been all it's a very simple matter. We hired an attorney who wrote a letter, it's a big name law firm, wrote a letter to the Department of Justice and to the medical board requesting a trial. And I have personally requested trial, and I have traveled throughout the state and attended board meetings. If you check board meetings minutes from 2008 to several years, I have attended board meeting and requested right to trial. We are only requesting a right to trial.
Sir, I'm going to have to, sir, I'm going to have to ask you to wrap up, but I look forward to receiving your written testimony, and I can assure you that we will carefully consider it, just as we will do your comments up to this point. I want to thank you for participating today.
Whom am I speaking with? Whom I will address that letter to? Whom I have pleasure of speaking with now?
Sir, I did not hear that. What was your question?
Sir, I am not on a Zoom call. I am on a phone call. I cannot see you. I apologize. I cannot see whom I'm speaking with.
Well, you're speaking to Senator Richard Roth. I'm the chair of the Senate Business Professions and Economic Development Committee, which is one of the two committees conducting this joint hearing today. We do have a number of public members of the public who wish also to offer comment. I try not to limit the testimony, but I'm going to have to ask you to wrap up at this point. So please send us your written comments.
I will send a letter, but let me just complete that.
Thank you very much, sir. I appreciate your testimony. Mr. Moderator next. Ma'am.
Thank you. Line 17, please go ahead.
Yes. Hello, my name is Rosanna Davis. Thank you to committee members and staff for the opportunity to speak today on behalf of California Association of Licensed Midwives. Thank you today for, in great detail, addressing enforcement under the Medical Board of California. I will touch on that briefly in my comments related to the licensed midwife program under the Medical Board.
Ma'am, let me just make a comment ma'am, before you proceed.
Pardon?
We are going to have a separate hearing on licensing, so I would appreciate it if you would restrict your comments to the material covered today, which has to do with the enforcement process at the Medical Board of California, and then I can assure you that I will give you an ample opportunity during our next Medical Board of California Sunset Oversight hearing, which is either on the file or will be shortly, to talk about licensing and other issues having to do with your subject. Okay?
All right, then I will very briefly comment on enforcement then. And that is under issue number 7 in the background paper, how will licensed midwife board benefit patients? With no training in midwifery, physicians who expert review licensed midwife investigations have no knowledge of appropriate standards of care and when or if they have been met. Additionally, without the right to review complaints, the midwifery profession is operating in the dark when it comes to identifying patterns which may pose a threat to public safety or that should inform quality control initiatives. Appreciate everyone's time today, and with that, I will conclude. I look forward to further discussion about sunrising the licensed midwife program. Thank you.
Thank you, ma'am. Look forward to hearing from you at the next hearing. Next, moderator.
Thank you. Line 46, please go ahead.
Hello, my name is Wendy Connect, and thank you for the opportunity to speak. As the patient, I was the victim of my surgeon's conflict of interest when I had reconstruction for a preventative double mastectomy due to my diagnosis of the BRCA2 gene. I had no idea that my doctor had been paid almost $500,000 for a device he used, never disclosing that it was experimental. That device exploded inside me. My initial complaint to the board was closed without investigation. I was not interviewed. It was opened again after a $1 million settlement, closed again, and then now reopened. But almost 5 years have gone by, and many more patients have been harmed, and one that I know of has died. What I would like to talk about is the proposed legislation, AB 1278, which is now before the Business and Professions Committee, that would have eliminated the need for this investigation in the first place. AB 1278 would mandate a doctor's disclosure of financial conflicts of interest involved in a patient's care, payments made by drug and device companies. This information is vital to the right of a patient to have fully informed consent. Had we, and I should mention now that my husband is a physician, had any idea that my surgeon was being paid hundreds of thousands of dollars by Allergan for the device he implanted in me, we would have had powerful information to ask the right questions. The onus should not be on the patient to know that the open payment site exists, to do the research, and then talk to the doctor. AB 1278 will also make the open payments website prominent and known to patients, fulfilling the intention of the Physician Payment Sunshine Act. It's time to make our physicians as accountable as your real estate agent or your financial advisor. Current law requires a doctor to disclose their financial interest in a facility they are sending you to. Surely it makes even more sense to know about their financial involvement in a drug or device they plan to use in your treatment. Thank you for supporting AB 1278.
Thank you for comments, ma'am. Moderator next.
Thank you. Line 27, please go ahead.
Thank you. Can you hear me?
Yes, please proceed.
Okay. My name is Monique Hine, and I am from Bakersfield. I am with the Fairness for Injured Patients Act. My representatives are Senate Business and Professions Committee member Senator Melissa Hurtado and Assembly Business and Professions member Assembly Member Rudy Salas Jr. I would also like to thank my Bakersfield legislators for their support for mothers and babies in Bakersfield. My grandson lived for 18 hours and died due to medical negligence. His mother's classic symptoms of preeclampsia were ignored by two physicians, leaving my grandson alone to face a postmortem C-section. Malachi suffered negligence with his mother, but he suffered extreme negligence independently as the doctors in charge of his care made a cascade of errors. In his medical records, there is no clear time for his birth. He was not given a medication immediately that was needed to fight respiratory distress syndrome, and the doctors took too long to transfer him by helicopter to another hospital, knowing they did not have the resources needed to save his life. Throughout my family's complicated grief, we have received nothing but grief from the medical board. We were discouraged from filing complaints on behalf of Malachi. We were told that it would not matter and that we cannot accuse the same doctor twice. In another accusation, Malachi is referred to as a fetus. It only stated that he was born and he died, end of story. My grandson was not a fetus. He was an almost 5-pound baby boy. His name is Malachi. He has the right to have a complaint filed in his name. It does not matter if he lived for 18 minutes, 18 hours, or 18 days. The medical board is not protecting our families. I believe that a public board member majority will begin to steer the board toward more patient-centered policies. We have a physician majority board, and it is not working. Since my family from holding physicians accountable, we turned to the medical board for accountability, but they offered no consumer protection. Negligent physicians should be responsible for their own enforcement action. Cost recovery should be implemented by the medical board. Why should the medical board pay for all the costs for prosecution, for certification, and probation when the board is facing insolvency? With physicians paying for their own prosecutions, it would give them more incentive to resolve cases because they would be financially responsible. We just can't talk about change. We have to take action now. Otherwise, mothers and babies like my grandson will continue to die. Thank you.
Thank you, ma'am. I'm very sorry for your loss, and I do appreciate the fact that you waited on the line to provide your testimony, so thank you for that. Moderator next.
Thank you. Line 20, please go ahead.
Good afternoon. Can you hear me?
Yes, loud and clear. Please proceed.
Excellent. Good afternoon, chairs and members. My name is Adrian Mohammed. I'm with the California Medical Association. We appreciate all the work the committee staff has put into the background report and look forward to continuing to work with both committees as well as the medical board in order to ensure maximum efficiency and efficacy of the medical board.
The medical board is tasked with the protection of consumers and the promotion of access to quality medical care through proper licensing and regulation of physicians. And while the California Medical Association supports the continued authorization of the medical board's current fiscal condition presents a significant challenge to meeting its objectives. CMA supports an efficient and effective investigatory process that protects consumers and keeps Californians safe. We support a process in which a well-functioning medical board has the tools and capacity to evaluate, respond to, and appropriately prioritize resources that will help ensure the safety of the public. We support strong consumer protections, and we also recognize the importance of due process and patient confidentiality concerns. Again, we thank you all, and we look forward to continuing to work with the legislature and the medical board through these important matters and through the upcoming hearings as well. Thank you.
Thank you for your comments. Moderator, next.
Thank you. Line 23, please go ahead.
Hello, my name is Ashley Ginn, and I live in Elk Grove, California. My representative is Senate Business and Professions Committee member, Senator Richard Pant. I'm with the Fairness for Injured Patients Act, and I'm here today to share the story of my mother, Teresa Ginn, who was a victim of medical negligence, which ultimately cost her her life.
Ma'am, let me stop you for a second. Ma'am, hello. We're having difficulty understanding you, so could you please speak slowly and try to articulate? It's probably our system here, but I want to make sure that we all hear your comments so we can take them into careful consideration, please.
Yes, sorry, I had my headphones in, so I took them out. Hopefully this is better. Is this better?
It is better. Thank you.
Yes, of course. So my name is Ashley Ginn. I live in Elk Grove, California. My representative is Senate Business and Professions Committee member, Senator Richard Pant. I'm with the Fairness for Injured Patients Act, and I'm here today to share the story of my mother, Teresa Ginn, who was a victim of medical negligence, which ultimately cost her her life. My mom started experiencing excruciating headaches in May of 2018. After insisting the pain was worse than your average headache, a CT scan was done and found 7 brain tumors. The tumors were later confirmed with an MRI, and we were told by a specialist that the tumors were most likely meningioma tumors, known to be slow-growing and usually harmless, and not the cause of her headache. My mom insisted that the tumors and headaches were related, but specialists continuously denied this, even when testing for the meningioma tumors came back negative, and none of the pain meds prescribed even slightly helped with the pain. One specialist even mentioned the possibility of my mom making up the pain she was having. After 6 months, the same specialist admitted they had overlooked my mom's scans and determined surgery was in fact needed. Due to these specialist negligence, what were believed to be harmless tumors, in fact, turned out to be a rare disease, Erdheim-Chester disease, that spread throughout her body for over a year without anyone having a clue. By the time the disease was discovered in July of 2019, my mom was too weak to undergo chemo and therefore did not have a chance against the disease. On October 30th, 2019, my mom lost her life at just 63 years old because the people responsible for her health and well-being ignored her cries for help. When I filed a case with the medical board, my mother's case was dismissed with no interview and no communication besides the basic form letter. My mother's 7 brain tumors were left untreated, pain simply diagnosed as headaches, and her providers admitted that they had overlooked her scans, but somehow, according to the medical board, this translated into treatment within the standard of care. The public has lost trust in the medical board, and I believe the first step in regaining the public's trust is by reformatting the board into a public board member majority. The physician majority board has made no attempt to meet their mission of consumer protection. It is time to expand the board to include 2 additional public board members. As families, we need accountability. The first step in seeking accountability for families like mine is to update the microcap and to revise the medical board into a diverse public board member majority. The only way we can improve consumer protection is by holding our providers accountable for their actions. Thank you for taking your time today to listen to my story.
Thank you very much for taking the time to present. Ladies and gentlemen waiting on the teleconference line, it's my understanding that we have at a minimum 20 callers left in the queue. We had a target completion time here actually at 1 o'clock, and I've obtained an extension till 2, and that leaves us 30 minutes left to do what we need to do, and there undoubtedly may be more callers who join the line. So I'm not going to belabor this. What I'm going to ask you to do is to try to shorten your comments, particularly when providing suggestions to the committee on specific changes as part of the sunset process. Perhaps you could adopt the comments of one of the prior callers, if you will. So, moderator, next.
Thank you. Line 21, please go ahead.
Hello, good afternoon. Thank you for giving me the opportunity to speak today. My name is Billy Early. I'm a national advisor for Black Doctors Matter, national advisor for the American Pain Institute, advocate for the World Sickle Cell Federation. I'm a contributing member for Doctors of Courage, and I'm a physician assistant healthcare advocate and former congressional panelist, briefing panelist in 2018 on DOJ corruption. First of all, I would like to make a comment that I think that the committee should establish a common sense approach to understanding what is really going on with the medical board, the Attorney General's office, and the Department of Justice. Today's testimony provides that there's over 120,000 doctors are investigated each year by the medical board and the Department of Justice. However, there is absolutely no reference to how many state police officers, investigators, prosecutors, or other government employees are investigated. I have the answer. I believe it's zero. This is a common sense question to the committee and a response. Imagine there's over 1 million investigations a year by the Department of Consumer Affairs, the DOJ, and the Attorney General's office. These are 21 agencies, all these investigations, and allegedly there's none of these investigations involve state police, DOJ, or medical board misconduct, their employees. This needs to be addressed by the committee. And to wrap it up, the medical board has a written policy that they will not investigate complaints made by the public. And it's written. I have documents. I would like to provide that to the board. I would also like to ask the board to consider a review committee for Black doctors, Black patients, because the patient-doctor relationship is crashed in the state of California. Black doctors are critically low, their numbers with underrepresentation, and this all needs to, this board, this group has the power to help Black doctors and Black patients, connect again and build that relationship.
Thank you very much. Sir, is that your conclusion?
That's my conclusion. I would like to submit something to your staff.
Please do.
I have something I've written down. But
please do. Given our time constraints, written submissions are certainly appreciated by any of the callers on the line. Next, please.
Thank you. Line 43, please go ahead.
Yes, hello. My name is Hannah, and I'm a physician of color, a co-director of Black Patients Matter nonprofit 501c3. So between the complaints of the medical board not doing enough, lengthy and expensive costs to bringing complaints to accusations and protecting physicians, I am here to tell you the primary reason why. It is because they are not FOBs, friends of the board. The medical board is being misused to target physicians who treat patients of color. I'm the only person here today who is the Black patient advocate, a licensed physician, but not in California, and a winner of multiple federal civil rights lawsuits in different jurisdictions. Unfortunately, at the time my license was revoked in California, I was also a whistleblower. So I am here to tell you that, as Mr. Early has stated, there is a great deal of corruption that's occurring. So what happened in my case was that in 2017, I was working at a hospital in California. I complained. They stated that I was acting odd, strange. The medical board filed an emergency ISO, interim suspension order, based on the fact of myself acting odd. But their psychiatrist stated there was no mental illness, but the medical board spent all that time and money pursuing my license, and they failed. Then I filed a federal civil rights lawsuit. It's still ongoing since January 2018. And during that time, they revoked my license. And the way they did it was very, illegal and corrupt. So basically, the solution is this. I'm here to offer you solutions. First and foremost, you need to have members of the medical board that have significant work experience in promoting racial diversity and religious tolerance. So Dr. Kraus, who I know quite well since we were together, that I had seen him several times as a former member of the CMA and other organizations. Undoubtedly, he's brilliant. I mean, MIT, the resume is pages long, but his resume reads as someone who avoids any type of work in relation to racial diversity and religious tolerance. We cannot have that in the state of California. Granted, people in the medical board, there's several. It's not just him. It's himself.
Doctor.
It is also lawsuits of others.
Doctor,
yes.
Unfortunately, given our time constraints, we don't have the time for long presentations.
Yes,
so
I'm almost done.
I would suggest that you get to the point.
30 seconds.
Okay.
So the solution is this, is that the medical experts they have at the medical board, they have an extensive, impressive resumes, but their resumes, the majority of them do not have any type of work experience in racial diversity or religious tolerance. So it should be required that in the state of California, as diversified as we are, we need to require our medical experts and our consultants to, this kind of diversity training. It doesn't work. Now we should have them required to have significant work experience. Them going off at MIT and all that's very impressive, but for the state of California, if they don't have significant work experience in racial diversity, religious tolerance, and LGBTQ rights, they can't be a medical expert. Thank you.
Thank you, Doctor. Moderator, next, please.
Thank you. Line 73, please go ahead.
Hi, thank you so much for your time and the opportunity to speak to you guys. My name is Mark Antiputi. I'm an emergency room resident physician at UC Davis Medical Center. I wanted to talk about the sunset review process for the PTL, if this is the appropriate time for that. So I'm here today on behalf of my union, SEIU-CAR, representing resident physicians throughout the state of California, primarily to raise concerns about the impact of the postgraduate training license, or the PTL, on myself and fellow resident physicians. We as physicians go into medicine to help people, and the PTL has unfortunately been hurting patients' access to care, especially during the times of COVID. Residents just 1 year above me who have an unrestricted license spend much of their free time at community clinics and hospitals helping our most vulnerable and gaining valuable experience working with Medi-Cal patients.
Sir?
I and many of my colleagues who
Sir?
Yeah.
We're going to be taking this issue up at the next hearing, the next sunset review oversight hearing of the medical board, and that hearing will cover licensing and a variety of other issues, including the specific issue that you're addressing. So what I would ask you to do is revisit us at our next hearing, where that issue will become more relevant to the testimony and the presentations. Is that okay?
Perfect. Yeah, thank you. Sorry about that. Do you know when that would be?
If you'll contact the consultants of either committee, they will brief you on the timing and make sure you have a copy of the agenda, okay?
Perfect. Thank you so much. Appreciate it.
Thank you, sir. Moderator, next.
Thank you. Line 32, please go ahead.
Hello.
Hello. Please proceed.
Can you hear me?
Yes, please proceed.
Okay. Hi. Okay. My name is Tracy Dominguez. I am from Bakersfield. I am with the Fairness for Injured Patients Act. I want to acknowledge my Bakersfield legislators who have shown support for Kern County mothers and babies. My daughter was healthy and monitored her pregnancy closely. She was so excited to attend her college graduation, but she never got to wear her cap and gown and to accept her degree because she died due to medical negligence 1 month before her college graduation. My daughter had a healthy pregnancy until extreme swelling turned into a condition where my daughter couldn't breathe. She had vision problems, protein in her urine, and blood pressure, high blood pressure. She had every sign of preeclampsia, but those signs were ignored by 2 doctors. She tried so hard to get help for her her unborn son. But her doctors would not help her. She was in trouble, but her regular OBGYN would not see her, so she went to the local hospital in need of care for herself and her unborn son. What she didn't know was that the hospital on-call doctor was a repeat offender that the medical board allowed to continue to practice, knowing that he was linked to deaths of 6 mothers and babies. They were not only his victims. There's a long list of victims with a clear pattern of negligence. After my daughter's death, we have been discouraged from filing complaints. We had an investigator come to my home without warning before we even filed a complaint. We have been interviewed by an investigator and integrated by making us feel like we did something wrong. Once we were finally able to prepare our complaint, we were discouraged from doing so, telling us that we already had been interviewed. Well, we were interviewed without even going through the medical records, without preparation. We came forward with new information, and we had to fight every step of the way to get it to the medical board to accept our new information. I learned that one of her doctors had been harming mothers and babies in Bakersfield for 25 years. Sadly, she had previously changed OBs when she had learned that her prior doctor had been disciplined for sexual misconduct. Searching for another health care, she changed doctors only to die at the hands of another dangerous doctor. The medical board has no value for mother's life. How could the medical board justify allowing a doctor to continue to practice knowing he is linked to deaths of 6 babies and harming women for 25 years? The board keeps offering him probation. How many mothers will have to die before the medical board revokes his license? The medical board failed my daughter and many other young mothers and babies. The current system is broken. We need a change, and I believe a public board member majority is the change we need. It is a starting point to rebuild the public's confidence in the board that puts the livelihood of doctors over human life. With a micro cap in place and no accountability for families, we file complaints with the medical board and to find no accountability there either. I blame the medical board for the death of my daughter and grandson. It is the board's responsibility to see a clear pattern of extreme negligence that affect mothers and babies. Where else can someone be linked to deaths of 6 people and be placed on probation? But the medical board keeps giving him probation and protecting the doctors over patients. It is now the time to overhaul the medical board. If you don't have the will to do it, so then sunset the board. You did not protect my daughter. You took my daughter's future away from her family. That's it. Thank you very much.
Thank you, ma'am. We're very, very sorry for your loss. I know it's very difficult to talk about, but I want you to know that we do appreciate your testimony today. Moderator?
Thank you. Line 16, please go ahead.
Hello. Thank you for the opportunity to speak. My name is Alka Airy, and I'm from San Francisco. My representative, Assembly Member Philip Ping, is a member of the Business and Professions Committee. I am a volunteer with the Fairness for Injured Patients Act campaign, and I would like to share how the medical board failed my sister and our family. I believe reform is desperately needed to restore the public's trust in the medical board. I lost my sister Shilpa to medical negligence. An anesthesia error at age 43 destroyed my sister's lungs to the point of requiring a double lung transplant. Her physicians waited too long to list her for a lung transplant, and she died just 1 month after her listing. She never received a lung transplant. Her death was entirely preventable. Micra prevented our family from holding the physicians and hospitals accountable after her death, so we turned to the medical board in the interest of public safety. Within weeks of filing a complaint, the medical board dismissed our complaint without action. There were no interviews of us or the physicians. Evidence outside of the medical record was not considered. The Department of Public Health made a subsequent referral to the medical board, but there was no follow-up. I even reached out to the medical board's executive office, and again, no response. Eventually, after much persistence, I spoke with a coordinator at the medical board who confirmed there are no interviews unless a complaint escalates past initial review, which is a very small percentage. Physicians are given optional questionnaires to complete, and few ever do. Only the medical record is reviewed. Emails, voicemails, or even patient notes are not reviewed. There is no appeal process after a complaint is dismissed. I don't believe the medical board's current investigation process is adequate. How can it be called an investigation without a single interview, without a review of all records, and without any opportunity to discuss information? By refusing to review evidence outside of the medical record, the medical board demonstrates a bias in favor of physicians and hospitals. Thus, it isn't surprising that the public has lost faith in the medical board as an oversight body. We can't afford the status quo with the medical board anymore. We need to strengthen physician oversight before more lives like Shilpa are lost to medical negligence. Thank you.
Thank you for your testimony. Moderator, next, please.
Thank you. Line 30, please go ahead. We'll go to line 40. Please go ahead.
My name is Michelle Montserrat Ramos, and I'm from Los Angeles. I'm the Kathy Olson Patient Safety Advocate with Consumer Watchdog, and I work with families across the state of California who've been harmed by medical negligence. I became a statewide and national advocate following the tragic death of my husband-to-be, Lloyd Montserrat. Lloyd entered a Los Angeles hospital for surgery and died 3 days later with no cause given for his death. I had to launch an investigation on my own. Two coroner's reports concluded that Lloyd died from surgical errors, an untreated surgical site infection, and septic shock. I also discovered that Lloyd's surgeon had a long arrest record for possession of crack cocaine and prostitution. There were other victims as well. What pains me was that I went to the medical board website and searched for information on Lloyd's doctor, but his profile was clean. The board had information on Lloyd's surgeon that he did not have the right to know. This lack of transparency cost Lloyd his life. I can't emphasize enough how incredibly difficult death by medical negligence or a death that could have been prevented is to cope with. Yet when families seek accountability and justice through the medical board, we soon find out there is none. There was no accountability for Lloyd. He died tragically, yet the medical board found his death not worthy of investigation. His complaint was dismissed at the Central Complaint Unit with no interview, no opportunity to challenge it, nothing. I also face a lack of accountability due to the microcap. 46 years ago, when the legislature imposed the cap and took away legal deterrence for harm done by physicians, the medical board's powers were enhanced with the promise that the board would fill in that accountability gap. That promise was never realized. This is not my first sunset review, and it is not Consumer Watchdog's first sunset review. For decades, we have watched the legislature make changes around the margins and give the medical board another 4 years with their promise to change. Yet the same failures continue. It is time for a complete overhaul of the board. If you die anywhere else in California, your death will be investigated. Yet, when our loved ones die at the hands of a doctor, the majority of those deaths, like Lloyd's, are never investigated. I work with many of the families you are hearing from every single day. We need you to commit to your constituents and our families that you will overhaul this board and truly make consumer protection paramount. Thank you.
Okay, thank you very much. Here's the batting order next. We have 15 individuals still in the telephone conference line queue. There may be more. We have 10 minutes to go till 2 p.m. I would suggest that individuals in the future try to limit their comments to 1 minute, because for every minute over that you use, you may be cutting off someone else at the end of the queue who may or may not be able to comment. So let's try to limit comments. Moderator, next, please.
Thank you. Line 30, please go ahead. Line 30, your line is open. Please go ahead.
Next, moderator.
Line 25, please go ahead.
Hello, can you hear me?
Yes, please proceed.
Thank you. And I do want my time to speak because you gave the medical board time to tell their lies. I didn't want to start on a contentious moment, but I've been housebound from being surgically assaulted for over 9 years. And I think that I deserve a chance to speak more than the medical board. My father was a highly regarded ethical pediatrician and researcher who wrote multiple papers that bettered medical care in the 1960s. And this field in California is completely different than what I grew up with. My own career was as a physical and behavioral therapist, a grounded support for people, until Saul Berger surgically battered me. Now I'm in a living hell and at risk for homelessness. So how did this happen? In 2011, my doctor referred me to Saul Berger for a conservative breast reduction for structural reasons. I really resent that I have to rush through this, by the way. It is not okay. You know what you should have done is make more time for public comments, because this is huge. Anyway.
Well, ma'am, let me make a Let me make a suggestion. Yeah. Instead of commenting on the process here, why don't you concentrate on your statement, and let's see how far we can get through, okay?
Yeah, but I feel like I'm letting other people not comment then, and you put me in a bad place. Well, and I'm in incredible physical pain.
Let me worry about the line in the queue. I just ask public comment callers to try to limit their testimony.
I'm going to give my public comment. You have to understand I'm in incredible physical pain since 2011. Berger's ambulatory center presented a slick facade walled with certificates which imbued the belief I was in a safe medical establishment. His credentials checked out via medical boards. I trusted these doctors until Berger egregiously assaulted me. Lawyers and others say it looks like a Dr. Mengele job. I sent you a 10-second video which illustrates the undeniable atrocity Berger did. By the way, I've been sending all of your offices this video and information for all these years. No one has helped yet. Berger left me excessively bloodied, in intractable pain, unable to support myself or complete tasks of daily life. I couldn't even drive to get help, and the referring doctor colluded with Berger. She wouldn't even put me in a gown to examine me. What Berger did was brutal and vile, not an error. After his life-destroying assault, he lied to cover up for himself, which caused me more medical harm. Yet, unbelievably, the medical board still licenses him. I filed a medical complaint against Berger for assault, gross negligence, and fraud. It passed the initial interview, which was really nothing. Some woman coming to my living room. My doctor wrote to the board about how I've been scarred for life, disfigured permanently, constant pain, trying to rush this. Because of the overly aggressive and unconsented surgical procedures that Dr. Berger performed. This constitutes surgical assault. There are other doctors and experts that have demonstrated and testified that these areas were damaged and consent had not been obtained. The board denied my valid case of surgical assault against Saul Berger on April 24th, 2017. It's not complex. The board never reached out to my own doctor. I provided plenty of clear information. It's a crime. Surgical assault causing serious bodily harm is a violation of the standard of care. Christina Delp, former DOE, urged me to take this case of battery to the police and the DA, but law enforcement says medical battery is outside of their purview unless the medical board tells them to investigate. Since the medical board doesn't do real investigations, this puts doctors who assault above the law, and Californians suffer for it. I appealed to the Department of Consumer Affairs, which by then was headed by Kim Kirchmeier, who had gaslit me. The DCA report is filled with fraud and slander. Burger is not just a bad apple. The field is corrupt, advertising is insidious and untruthful, and doctors' lobbies and boards go against patient safety. The board has this ongoing thing about cosmetic versus plastic surgeons. It's completely off base because liposuction and other procedures they're doing are scams. And they're scientifically proven to be scams, and licensure doesn't make them safe. The biology of fat, the invasive nature of procedures, carte blanche, and covers up. This isn't even medicine. Dr. Gutowski said some states like California have passed liposuction legislation based on a guideline. There's no data behind it, no science. By the way, I went for breast reduction. The LA coroner's list of people who died due to liposuction is, guess how many women? 100%. Average age is less than 48. This preventable harm caused by plastic surgeons for healthy women is gender-related violence. Doctors mislead, use short-term anecdotes, ignore science, and silence survivors via threats, gags, and slander. People will say they want changes to their body. It's their right to get them. But hundreds of women I know, and thousands of reviews online, because I've been housebound studying this for 9 years, said they were lied to and harmed by plastic surgeons. The common wish is that she had a time machine to get her good life back. Now, there was a plastic surgeon, Robert Yoho. He had 2 women die in his surgery center, plus other serious complaints. 12 medical malpractice lawsuits I counted online. Dr. Kenneth Hughes came before the medical board on 2 counts of wrongful death in May 2019. The medical board said their own expert was corrupt and lied profusely. The cases were dropped. The board is failing. Lawyers don't want the cases due to MICRA, even if you get to trial like I did. These unscrupulous doctors and lawyers look to profit off patient harm. Now, reality show surgeon Terry Dubrow, when he came as the IME in my civil case, he lied. Tom McAndrews, Berger's lawyer, lied. They participated in this dishonest trial. And Dubrow said in the depot he works repeatedly with McAndrews' firm. McAndrews represented those guys I mentioned earlier, Yoho and Hughes and Berger. So talking to McAndrews is not a sufficient medical board investigation. The medical board hires Dubrow as an expert. Now, this empowers him. In his own practice, you should just read his Yelp reviews for beginners on TV and to lie in depot in court. It's no secret the medical field is controlled by money. Some plaintiff lawyers try to get victims to settle for $29,900.99 with a full gag clause so they can get paid and walk away and the doctor's protected. When I was pro per, McAndrews served me with 7 limited motions. Trying to skip whatever I can here. There's a rush to get murderers off the street, but not so with your deadly or disabling doctors in California. I'm skipping most, so most women I know harmed don't file medical board complaints. Everyone knows that the board isn't going to do anything. Look, I was mutilated alive. Looks like a Mengele case, and they did nothing. Women don't want to go through more harm. And one doctor on the board says you can't hang everyone. Anyway, so here's my question. Where does one report California when California agencies are dishonest? In my case, the medical board and DCA acted corruptly. The governor's office is horribly dismissive. The mayor gave the assaulting surgeon a plaque for 25 years of successful practice 6 years after the assault. Really, you think I contacted his office for years? They do nothing. This gross negligence empowers abusers, enables medical carnage, and robs survivors of their voices. Now, if you continue to indemnify these dangerous doctors, then I'm trying to skip stuff. First of all, the plastic surgeons who practice scam procedures, like liposuction and others, are the last people who should be called as reviewers or experts in fellows' cases. They're all covering each other, and they're all doing the scam. Doing so perpetuates the duplicitous branch of medicine. Considering that rapists and assaulters do not write about abuses in their notes, looking to a doctor's records is baseless. It's useless. There has to be patients co-authoring their records, because this is what's used. Just about everyone who suffers malpractice will tell you the records were fixed, they're wrong. And even well-meaning doctors can get things wrong. And I'm finishing up. I listened to the testimony by the board. What they said has no bearing on reality. It's not just semantics. And if you vote to allow this board to continue, it will solidify your choice to participate in these crimes against women. And I'm urging you not to. And I want a better forum to get things passed that will actually protect patients. I have been studying this for 9.5 years. And I want you guys to give me a way, because every one of your offices, except the new people, have gotten multiple calls and letters from me, and you've done nothing.
Well, let me make a suggestion.
Thank you for your time, and I hope I didn't take away from someone else.
Well, ma'am, let me make a suggestion. You obviously have material written down, and if you will send your written statement, which you obviously must have if you're skipping through, if you'll send your written statement and direct it to me, Roth, R-O-T-H, I will make sure that it's a part of the record of this proceeding and will be carefully considered as we move through this sunset oversight process and determine changes and procedures for the medical board moving forward into the future. So I want to thank you for your comments and for your patience in waiting. And again, thank you very much. Moderator, next.
Thank you. Line 84, please go ahead.
Hi, this is Eric Anders from the Patient Safety League. Oh my gosh, I had 4 minutes prepared, whittled it down to 2, and I had to throw everything out because I need to address some things that the medical board lied to you during this conference. Please read our report that we sent to you earlier this week. It's interesting that Mr. Prasiska is feeling bullied, because that's how victims and advocates feel treated by the medical board at every turn and at every quarterly meeting that we attend. He says they'll listen to any suggestions to improve, but he won't even interact with me, refusing to answer any email I send him. There is a mandate, I've heard, at the board to never interact with me. They don't like that I can use their own words to prove them wrong. Talk about semantics. Terry Webb is often quick to say they're not allowed to punish, but as any doctor who has been railroaded by the board into revocation if they don't think they're being punished. Regarding your early questions regarding the contacting complainants, the board never contacts the complainant upon receiving a complaint. And I have emails from the MBC employees stating that it is not their policy to do so, which I provide to the committee. I have never been contacted on any complaints I've filed. In my sister's death case, not only did they never contact me, they never got a certified copy of her medical records from the hospital, and they never even saw the private autopsy report. They just closed the complaint outright. When I did a public record request to find out what happened, to see if the expert was even qualified, they denied it in its entirety. They didn't even try to redact it. Regarding the case that General Roth brought up about Dr. Klein, Mr. Prasiska is trying to pull the wool over your eyes. NBC knew about this case as far back as 2016 and likely earlier. And that information is exposed in the Mercury News article of August 12, 2016, where they talk about the medical board knowing about it. Crimes of death and sexual assault are supposed to take precedence. You also asked about deviating from the guidelines and making sure that's explained to the public. The board often does not put that information in public documents, and they violate the Public Records Act rampantly, often denying requests outright instead of redacting and or wanting to charge exorbitant amounts so as to make the request unfeasible to the requester, which is in direct defiance of the Public Records Act. One such disciplinary case is Dr. Daniel Hedrick, who overdosed a young man to death. He was charged with repeated negligent acts, unprofessional conduct, and failure to maintain adequate, accurate records. The minimum, according to the guidelines, is 5 years probation for just one of those things. He ended up getting a public reprimand, and there's no explanation in the decision as to why the guidelines were deviated from. So he got a public reprimand when someone died. This doctor then went on to public TV and bragged about the lenient discipline by the board. Dr. Pan, they can't even deal with the submitted consumer complaints as it is, let alone scan for cases to initiate themselves. They do not investigate after finding out about malpractice settlements. We can prove it with multiple cases in our database. Jenna Jones was not truthful with you on that.
Thank you, sir.
Dr. Kraus says they never.
I'd ask you to please wrap it up. We've got several others in the queue, and I can assure you that what's going to happen at 2:30 is the telephone conference line operators, vendors are going to pull the plug on this, and we're going to leave a whole bunch of people without a forum. So would you please wrap up?
I totally understand, and I will send you this stuff, but you really should have planned for this, because we know from past sunset reviews that the public always takes a long time to talk. So we're feeling a little bit dissed by this, that you allowed them so much time to speak, and now you're cutting all of us off. So I will send the rest of this to you, because I have enormous amounts of evidence that I can prove almost everything that the medical board told you guys today wrong. Thank you.
Well, I tell you what, most chairs limit public comment to 1 or 2 minutes, and I think you will agree, if you've been listening, that I am not one of those. So I would ask you to wrap up, and if you have it in writing, submit to us, and I'll make sure that it becomes part of the record and is considered as part of our sunset oversight process.
But everybody read the report that we submitted to you all on Monday, because it's 95 pages of very strong evidence. Thank you.
Thank you for your comments and for your written reports. Sir, next moderator.
Thank you. Line 28, please go ahead.
Hi, I am offering this testimony on behalf of Kimberly Ortiz, grandmother to Celeste Ortiz. My name is Kimberly Ortiz, and I am from Bakersfield. I am with the Fairness for Injured Patients Act, and my representatives are Senate Business and Professions Committee member Senator Melissa Hurtado, and Assembly Business and Professions member, Assembly member Rudy Salas Jr. My granddaughter successfully delivered her beautiful daughter with no problems. She was so happy to see her baby for the first time, but then the unthinkable happened. Immediately following giving birth and with no consent, her doctor forcibly removed her placenta, first by hand, then by forceps, and then again by hand. I could hear my granddaughter's agonizing screams from down the hallway. While forcibly removing her placenta, he perforated her uterus and cervix. My granddaughter bled to death while the nurses begged her doctor to help her. Her doctor gave her no life-saving support. Her vitals plummeted while she died. We were faced with the challenges of MICRA with no accountability in sight. We went to the medical board and filed a complaint. My complaint was investigated, and I was told that this repeat offender doctor would have to go to a hearing before an administrative law judge. He had been on probation before for the deaths of 2 babies. While we felt that he would finally be disciplined for my granddaughter's death, but that did not happen. He was offered a settlement, a plea deal, that gave him probation once again. The medical board knew that this doctor had been harming mothers and babies for over 20 years, but they continued to allow him to practice and continue to harm others. Had the medical board taken his license earlier, the young mother and baby who died after my granddaughter Celeste would be here today. I am devastated. The medical board is failing our families in Kern County. We cannot continue to have doctors police other doctors. I believe that a public board member majority is our only hope for some protection for our families. We need action now. We need a complete overhaul of the enforcement process. My granddaughter didn't have a chance, but make the change to save another mother. Thank you.
Thank you for taking the time to provide those valuable comments. Moderator, next, please.
Thank you. Line 68, please go ahead.
Line 68, is that me?
Yes, please proceed.
Please go ahead.
Oh, excellent. Excellent. My name is Andrea Hedstrom, and I want to start by saying, first and foremost, do no harm. It is clear to me that this governing body, the legislature, and the California Medical Board have totally lost track of the Hippocratic Oath and their responsibility to the people. That you are even limiting Californians who are telling personal and painful stories in this hearing is such an insult and so offensive. There is no reason you could not stay until 5 o'clock or even midnight to listen to Californians. After all, you work for the people. I had the opportunity to become acquainted with and attend a board meeting of the California Medical Board in person prior to the lockdown. What I learned that day shocked me. I could not believe the instances of death and suffering with zero accountability. listening to these comments today has confirmed this once again. I am truly horrified by the stories of death and suffering experienced by Californians with zero accountability on the part of the California Medical Board. It is so horrifying to me that these injuries and deaths are not investigated, and you, the legislature, are complicit in it. And you, Senator Ross, patting yourself on the back for not limiting people to 1 to 2 minutes of comment, when they are telling the stories of the deaths of their family members?
Ma'am, I would ask you. I would ask
and in
you.
the midst of all
I would
that,
ask you. I would ask you.
to hear Senator Pan say in this very hearing that he wants stricter penalties for doctors who write
Moderator, next,
for
please.
vaccines is a sign of still more corruption.
Thank you. Moderator, next.
Thank you. Line 24, please go ahead.
Good afternoon. Can you hear me well? Can you hear me?
Perfectly, loud and clear. Please proceed.
My name is Mario Guzman, and I am from San Jose, California. At age 42, I was injured by a negligent physician after she misdiagnosed me repeatedly what were clear signs of severe sepsis. The board ensured that the doctor remained with a spotless record despite finding her care negligent, while I have been mutilated for the rest of my life. Mine, like 95% of all complaints, was shelved, sealed, and closed, with no explanation, no justice, no accountability, and most importantly, no respect toward the injured patient or the families. As it's set up today, the California Medical Board is a sham of a consumer protection agency that spends millions of taxpayers' money with less than 3.5% of complaints ever making it into the Attorney General's desk. But even after that, disciplinary action is elusive. Most are given useless letters of reprimand, while just a few ever encounter probation or suspensions. And this happens because it is absurd that doctors should police themselves with no accountability to the public. That is why it is essential that members of the public make the majority of the medical board, because what we have right now are just lobbyists acting like policemen of the same lobby groups that they are supposed to oversee. It is also essential that the complaint process is transparent and open to the patient, with clear timelines and communication during the investigation process, because as it is right now, it feels to the victim as a black box of which nothing resembling justice comes out. Not only that, but we believe that the patient should be present or at least considered when issuing disciplinary actions, as it would be in a criminal trial when sentencing, because I know for a fact that if I have been present at such hearing, a judge would have found it hard to dismiss my quadruple amputations caused by gross negligence with just a letter of reprimand. Lastly, there should be an impartial ombudsman figure that has the financial, political, and legal authority to act on behalf of the public, especially when it is evident that the board does not. Thank you.
Thank you, sir. Next, please.
Thank you. Line 90, please go ahead.
Thank you. My name is Marion Hollingsworth, and my comment is just 2 minutes, so thank you for giving me the time. Good afternoon. My name is Marion Hollingsworth, and I became a patient safety advocate after the death of my father from deliberate medical harm. My father was given antipsychotic drugs without any assessment or consent, which caused his death. This was totally preventable. After I complained to the medical board, the investigator promised an accusation and probation for the doctor who overprescribed and then falsified a do not resuscitate order. Later, I received a letter that said the doctor had been allowed to plead down to a public letter of reprimand. It took the board 3 years to post this PLR. Another doctor in my father's case just got a, quote, educational letter, or so I was told. I appealed this decision, warning that this doctor could harm somebody else if he was not disciplined. Just 6 weeks after my warning, one of this doctor's patients died from an overdose. This was part of the board's own death certificate project. This doctor was just given 35 months probation instead of the minimum of 5 years under the board's own disciplinary guidelines. If this doctor had been given 5 years probation as the guidelines recommend, he would have had to notify his patients of his probation under SB 1448. As an advocate, I read every discipline, and I can assure you that the guidelines are rarely followed. Why have them if they aren't even close to the recommended disciplines? This year alone, reprimands have been given for such egregious violations as babies and women dying in childbirth, sexual misconduct, and drunk driving arrests. One doctor had 4 patient deaths, yet was just given 3 years probation. That sends a message to doctors that the board will always have their back. It also tells people who lost loved ones and who have suffered harm themselves that they don't count, and that their lives or the lives of their loved ones aren't worth as much as the reputation of a doctor. And the board's own records show that these people must wait 3 long years for an investigation from start to finish, if they get an investigation. In closing, I implore you to conduct an audit of the medical board to see how it is failing the people of California. It's time changes were made, and for the safety of the people to come first. Thank you.
Thank you, ma'am. And to the extent that you have that written down, I hope you will submit your written comments to both committees so we can make this a matter of the record and consider this during our further sunset review deliberations with regard to the medical board. Thank you again. Moderator, next, please.
Thank you. Line 37, please go ahead.
Hello, my name is Xavier De Leon, and I am from Bakersfield, California. I am with the Fairness for Injured Patients Act. My representatives are Senate Business and Professions Committee member Senator Melissa Hurtado and Assembly Business and Professions member Assembly member Rudy Salas Jr. I held my son until he took his last breath. He only lived for 18 hours and died due to medical negligence. My son fought to live, but he didn't have a chance because the doctors overseeing his care made error after error. In his medical records, the doctors claimed that they transferred my son immediately to the NICU, but that isn't true. When I first saw my son, he was in a full seizure alone with no doctors tending to him. My son was only transferred to the NICU once I was there. How could any doctor, knowing my son's condition, leave him unattended? In the NICU, the doctor wasted time trying to enroll Malachi into a clinical trial instead of immediately airlifting him to a hospital with the resources that he needed. They waited almost 9 hours to transfer my son to another hospital as he fought for his life. After my son's death, I learned that one of his doctors had lost hospital privileges following the death of another mother. Following my son and his mother's death, the same doctor also lost privileges at our hospital, leaving the doctor with no privileges at any hospital in the city. The medical board took no action on this doctor losing hospital privileges. Wouldn't a loss of hospital privileges warrant a medical board investigation? The medical board is failing families. I believe a public board member majority will provide a more diverse voice since the microcap is not providing accountability for families. We go to the medical board to make the doctors accountable, but their focus is on protecting doctors over patients. I believe that adding 2 steps for families in the enforcement process, including the interviewing the family before dismissing a complaint and giving the family an opportunity to respond after the physician's interview, will give families a voice. Change needs to happen so no other father is faced with losing his family. Thank you.
Thank you very much for taking the time to testify. Next, moderator.
Thank you. Line 88, please go ahead.
Good afternoon, Mr. Chairman and members of the committee. My name is Denise Johnson. I'm an advocate with the Fairness for Injured Patients Act campaign and a constituent of Senator Eggman's in Tracy. I lost my 25-year-old son, a brain cancer survivor, when he was negligently denied treatment for pneumonia. I sought out legal counsel, but due to the 1975 law capping damages at $250,000, we were not able to hold anyone responsible. I was told that my only recourse would be to file with the California Medical Board. I filed several complaints. 3 years later, while still grieving the unexpected loss of my son, I got a phone call from a woman who said she was an investigator with the state medical board and was investigating my son's case. As requested, I explained to her my story. She giggled and laughed unbelievingly. I was unable to continue the phone call because I was so disturbed and upset by her lack of compassion. 5 years after my son's death, I received the first of 4 letters, all saying the same thing, that there had been an investigation which cited, quote, direct observation, interviews, and documents finding violations unrelated to our allegations, end quote. They said that they were, quote, unable to validate our complaint, end quote. To date, I'm fairly confident there was no investigation. I was devastated at the amount of medical mistakes made throughout the care of my son, but I'd been confident that the medical board would stand strong in defense of the patient and of human life. I was terribly wrong. There was no accountability from the agency responsible for enforcing it. I received no personal contact except for an insensitive, disinterested person on the phone and the additional coldness of form letters 5 years later. My son's life did not seem to matter to the medical board. The board only added insult to injury. I asked it to increase the number of medical public members on the board. We need a strong accountability system that is sensitive in its interactions with families, thorough in its investigations, and timely in its decisions. We all deserve high-quality medical care, but it is impossible without a strong accountability system. Please reform the board so that it serves the public instead of protecting negligent doctors. I thank you very much for your time and the opportunity to share my story.
Thank you very, very much for your taking the time to provide it to us. Moderator, next, please.
Thank you. Line 93, please go ahead.
Good afternoon. My name is Charles Johnson, and I'm the chairman of the Fairness for Injured Patients Act. And first and foremost, I want to just take a moment to acknowledge the bravery of the families who shared their stories today. It's simply remarkable. Mr. Chairman and members of the committee, the California Medical Board is killing mothers and babies. My wife, Kira, went in what was supposed to be a routine scheduled C-section at Cedars-Sinai Hospital on April 12th of 2016. And for 10 hours, she was allowed to bleed internally while myself and my family begged the staff at Cedars-Sinai for help. And our cries for help fell on deaf ears. Dr. Naeem, who was one of the doctors responsible for my wife's death, after an investigation by the California Medical Board, not only was he found grossly negligent in Kira's death, he was found responsible for the near-miss deaths of 5 other women, 4 of which took place within a 3-month time span of my wife's death.
Sir, would you speak up a little louder? I want to make sure we hear you.
Absolutely. Can you hear me now? I want to be sure that everybody can hear me.
It's better. Please emote, or whatever the word is. Thank you.
Okay. So let me be clear, and I want to make sure everybody can hear me, is that Dr. Naeem was not only found grossly negligent in my wife's death, he was found negligent in the death of 5 other women, 3 of which took place in a 3-month time span of my wife's death. And he was only given 4 years probation. 4 years probation, which is far below the California Medical Board's minimum standard sentencing guideline. And while I'm left, this man has been allowed to go on with his life while I'm left to explain to my 2 sons why their mother is never coming home. Californians deserve so much better. Californians deserve a recourse of civil action, far better than the outdated 1975 microcaps that limit the value of human life in California to $250,000. Californians deserve better. Californians deserve to know about politicians who are being pressured into taking and signing pledges in return for campaign donations to uphold these microcaps. And what I want you to understand is, for the members of this committee, you have an opportunity to send a loud message to your constituents that patients and families matter, and that you are willing to stand tall and hold doctors accountable. And what I want you to understand is for those of you who are not, or who may be on the fence of this, you are complicit in the deaths of these people. You are complicit in the maiming and the injuries of citizens of California. Do the right thing, take a stand, because what I want you to understand is that there's a new day coming in California where patients and families are going to stand together and hold people accountable, because if you are not willing to, we will be sure to make these doctors famous and infamous. Thank you for your time.
Thank you, sir. I'm sorry for your loss. I do appreciate your testimony. I will note for the folks on the line that this is not a hearing into micro. This is a hearing as part of our normal process to conduct a sunset oversight review of the Medical Board of California, review its procedures and processes to ensure that they're effective and efficient, and if not, propose and implement procedures that are through a sunset review bill. So I do appreciate the testimony. Next, Mr. Moderator, or Madam Moderator.
Thank you. Line 94, please go ahead.
Hi, good afternoon. My name is Sandra Perez, and I'm from Hesperia, San Bernardino County. And I'm here today with my husband, Anthony, to speak on behalf of our family and other patients who have suffered harm due to medical negligence. And we're also representing the Fairness for Injured Patients Act campaign. We are constituents of Senator Wilk, who is not a member of this committee. In 2018, a month before her 18th birthday, and 2 months before her high school graduation, our 17-year-old daughter, Jordan, died as a result of egregious medical negligence. Jordan wasn't just misdiagnosed. She suffered at the hands of the medical professionals we trusted to help her. Physicians ignored her symptoms, her test results, and lacked any coordinated care between specialists who continued to pass her along without direction, diagnosis, or treatment. We were later told, had the doctors done their job, Jordan would still be here. And to date, nobody has been held responsible. In early 2019, after Jordan's death, we filed multiple complaints with the medical board. After inquiry with Ms. Jenna Jones' office in 2020, all of our complaints were closed by the Central Complaint Unit without a complainant interview and no medical consultant review. We have had no recourse to appeal and no knowledge if we can resubmit as a new complaint. We were informed by multiple persons outside the state agencies that the medical board frequently closes complaints where the physician may be part of related active litigation. This requires clarification and forthcoming response from this board. Over the last year, I have learned that unless a complaint is filed in the context and jargon of the agency, complaints are likely to be dismissed without complainant interview or consultant review. As laypersons, the public is not familiar with all the components necessary for a successful complaint and associated review. In March 2020, I submitted a new complaint, this time cited and sourced, and still have not had an interview, and only an email request to provide Jordan's death certificate. This is the only one that just recently passed the Central Complaint Unit to the medical consultant, which directly contradicts Ms. Jones' testimony here today. The average process from complaint to discipline, if not dismissed, is approximately 600 days, which is not only unacceptable, but offensive. This is a systemic problem, and the people harmed by medical negligence deserve justice, and healthcare consumers deserve better. Years of doctors policing themselves have led to negligent doctors continuing to practice without any consequence. Coupled with the constraints of MICRA, the medical profession is left unchecked. We need improvement and transparency to the complaint process and enforcement. I support previous recommendations for more public advocates, for the complaint status verifications and checkpoints, complaint statistics to be online, interviews with the complainant at multiple steps throughout the process, and a cost recovery policy. Based on recent statements and lack of preparedness, I am not convinced all members of this board understand the gravity of the current abysmal state of affairs with the medical board, nor their responsibility for accountability to the public. This system is broken. I'd like to thank you for the opportunity to share our limited story here today, and I will send the full context of my statement for inclusion in the record. Thank you.
Thank you very much. Moderator, are there any other callers on the line?
Thank you. I have 4 left in queue.
Okay, please proceed. We'll try to get them all in.
Line 97. Thank you. Line 97, please go ahead.
Hello, can you hear me?
Perfectly clear. Please proceed.
My name is Ludmila Parada, and I am calling from San Jose, California. I wanted to come here and say a few words because in the end, this is a matter of humanity of decency and respect. I wish you could have seen my husband, how strong and healthy he was, and how he looks now. Where his legs were, there are stumps now. His only hand is a mangled one, and that is after 2 bouts of reconstructive surgery. He used to run marathons and triathlons, and now he's in a wheelchair for the remainder of his life. And the medical board allowed this to happen with absolute impunity. Like many cases that are testifying today, this is not just a mistake. Often, the cases that we see are doctors that year after year fail their patients and the public. According to the National Practitioner Data Bank Public Use File, just 5.9% of doctors have been responsible for 57.8% of all malpractice payments since 1991, according to data from September 1990 through 2005. Each of these doctors made at least 2 payments. In our particular case, the doctor failed my husband not once, not twice. She deviated from the standard of care almost a dozen times. The investigation of the California Medical Board agreed she was negligent, but it did absolutely nothing. My husband has no hands and no legs, and the most I could do is write a bad Yelp review. Doctors should not police themselves, especially when they have a track record like Dr. Ganana did of being part of the very same lobby groups. We need patient advocates as the majority of the board, because right now, doctors empathize with the doctors, with their peers, and not the victims, no matter if said doctors maim, rape, or kill you or your loved ones, or if they have drug or alcohol problems that make them a threat of treating a patient under the influence. A 95% failure to act rate with no accountability is unacceptable for any sort of justice system. And that is why I ask you that all of you act now to protect the patients of all California. The transparency is the norm for the complaint process, and that an independent advocate with legal, political, and financial independence is appointed to ensure quality and accountability. This way we can reform and improve at last the Medical Board of California. Thank you so much for your time.
Thank you for your presentation. Next, please.
Thank you. Line 78, please go ahead.
Yes, this is Dr. Uzun, Gavin Uzun, G-U-B-N-U-Z-U-N, from Los Angeles. I was in practice until 2011 for 20 years in Los Angeles area, Cedars-Sinai Hospital, UCLA, St. John Hospital, and many others, in total 7 hospital privileges. I've seen in 20 years, about 18,000 patients, and 2,000 of those patients are emergency room co-patients with no insurance or medical insurance, non-funded. I did public service throughout the Southern California for 7 hospitals, almost 20 years. Somewhat during my practice time, I had a big practice in Beverly Hills, Los Angeles. A lawyer and the wife works at the Deputy Chief Attorney General. I did not know at the time. One was my lawyer, the other was his wife. Opened a fake investigation on me. Eventually, I ended up on probation. That's a short story of the big United States legal problem. Huge legal justice issue that it can be written in the law book. So anyway, I have never had a negative peer review out of these hospitals. Never had a single patient complaint. Never had a single malpractice complaint. Now, I feel sad for all these victims that suffer from multiple doctor injuries. They didn't even get any reprimand, barely. And this is very, very interesting how procedural system in medical board and judiciary is failed to public, and also doctors. Doctors should not be forgotten, the good doctors that serve this public for years. Not just me, but many others. In addition to that during my probation time, I found out medical probation chief officer was conducting illegal action because I covered the big corruption in the judiciary system with the vice lawyer, attorney general's office. So they determined to take my license. They used the medical board chief officer, Rachel Lasota. And I filed a complaint at attorney general's office, 11/2014. Then I found out in my investigation, this lady was fired from the Homeland Security for stealing credit card money of taxpayers, but appointed as a chief medical board supervisor officer. My complaints in the medical board ignored. Christina Hayes says, I didn't know that. And Rachel Lasota says she knew it. So anyway, they gang against me, and they revoked my license illegally. And with no patient complaint, no single injury, they got one medical board expert that he lied on his resume. He was an instructor at Loyola University. He was a yoga teacher, instructor at Loyola University. This was the medical board expert witness. And I had two expert witnesses. One was a UCLA professor for 35 years of neurology. I'm a neurologist. He found nothing on my care during probation, as well as the other physician that monitored my probation. And we go to trial. Attorney General wanted to go to trial. At the end, Rachel Losada was not brought to trial. In the last minute, she was declared by psychologists mentally ill permanently. She cannot testify and give any testimony on this case. We asked for dismissal of the case. Judge looked at the other way, refused, and eventually they revoked my license. With no case law, no similar experience, no patient testimony. Patient were still the two records that they reviewed. Two patients, I can't give the name. They were supporting my care. They said, Dr. Uzun did excellent care. When the Rachel Losota sent the police to our home, I decided to leave him because I'm worried my safety. So this is what's going on. In addition to second officer in charge, he said, Kevin Morris, because of what's happening to Dr. Uzun, I didn't want to be part of the fraudulent medical board investigation. I am leaving my job to the Home Depot. This was giving testimony to my investigator, Peter Morrell, and the doctor supervisor officer, Roosevelt Young.
Doctor, I'm going to have to ask you to, Doctor, I'm going to have to ask you to close it out and to submit your statement, your written statement to us for our consideration. But I do appreciate the fact that you took the time to present.
1 second, Senator. I respect your intelligence. You're very critical, very smart guy. I'm listening your last 4 hours. I think I deserve 4 minutes. I respect you highly. And I think medical board should not focus on medical record review and try to find something like on my case for 10 years spending $10 million while public injured on the right side, and they don't give any punishment to these people while I've been serving faithfully the community and the patient, and because of something happened on the line with the judiciary, they determined to revoke my license with no basis whatsoever.
Right, Doctor. Listen, I look forward to reading your written submission. We're going to have to move on to the last, I believe, 2 callers before AT&T pulls the plug on my conference line here. So I do appreciate your participation. Please send me your written statement. I promise to read it and incorporate it in our record of this oversight hearing. So thank you. Moderator, next, please.
Thank you. Line 100, please go ahead.
Hi, good afternoon. Chair Roth, Chair Lowe, and committee members. Thank you so much for extending the time and giving me the opportunity to share with you today. My name is Tammy Smick, and I live in Temecula. I'm a constituent of Senator Melendez. I'm a patient safety advocate and board member with Consumer Watchdog. I became actively involved in improving patient safety after my 20-year-old son, Alex Smick, was killed due to medical negligence. It was my worst nightmare. Not only did I lose my child, but he was killed by the very medical professionals I entrusted with his care. It was in an Orange County hospital that Alex was given a lethal combination of medications, and then he was left unmonitored for more than 7 hours. He was found dead in bed during morning rounds, and he was already in rigor mortis. I turned to the Medical Board of California to stop this dangerous doctor from killing another patient. I thought surely this regulatory agency would do the right thing and take swift action against the dangerous doctor who killed my son. I thought they were there to protect the public, but I was so wrong. My complaint against Dr. Daniel Hedrick involving the death of Alex took four long years to reach a decision. After the Attorney General's office filed an accusation recommending strict disciplinary action, including revocation of the doctor's license, a secret backroom deal was struck, and the doctor got away with a public reprimand, nothing more than a slap on the wrist for killing my son. the medical board completely went against their own disciplinary guidelines, and they didn't even have the decency to talk to me. I was informed via email after the decision was finalized, and I had to weed through a multi-page document to determine the outcome. The complaint process was cold and insensitive to my grieving family all along the way. The mission of this medical board is to protect healthcare consumers, but my experience and the experience of countless others show that they would rather protect dangerous doctors than protect patients. I believe this problem is allowed to persist because of the physician-controlled medical board, and so I fully support a public member majority to help ensure that the medical board fulfills its mission of patient protection. It's long past time for change. I testified before this committee 8 years ago, and I am deeply saddened and frustrated that so very little has changed to protect the public. I implore this committee to help us, to help protect all healthcare consumers in California. And I would appreciate and welcome the opportunity to work with you on meaningful reform. Thank you so much, and thank you for extending the time and giving me the opportunity to share with you.
We're truly sorry for your loss, ma'am, and I do appreciate the fact that you stayed on and took the time to speak to us today. Moderator, next, please.
Thank you. Line 30, please go ahead.
Hello, can you hear me?
Yes, please proceed. Speak loudly.
Hello, can you hear me?
We can,
Hello.
Loud and clear. Just make sure you speak loudly,
great.
please.
Oh my God, I've had so many problems with this. Okay, so I'm Edwin Kendrick. I'm a vascular surgeon out of Los Angeles County. I actually am president of the Health Equity Technology Company, member of Charles Drew, and I'm actually a constituent of Senator Roth. What I wanted to talk about is everything everyone has said, I agree with. I agree there's dangerous doctors. I agree that there's a system that does not allow the process to proceed as it should. I also agree that there's an issue when it comes to diversity within healthcare. Currently, 43% of Black physicians that have a license in California will be reported to the medical board and subject to licensure issues, whereas Asian and white physicians are in the 20th percentile. This is the data from the CRB that was published back in 2017. What I can tell you is that complaints that get sent to the medical board often will try to persuade complainants, including physicians, not to file claims because of even retaliation. This includes even workplace violence. The medical board experts, I've had a chance to look at them. They have significant flaws when it comes to being able to have full competency of the actual specialties that they're supposed to represent. In addition to that, when the medical board does get cases, and for instance, let's say it's a high-profile hospital case, the medical board has been known to transfer a case from outside of the community, in close proximity of the hospital where the medical board member is located. And not only that, but the same hospital will have an executive at that location who can interfere with that case. This is actual facts that have happened. What my goal has been is looking at this 2017 California Research Bureau report, I noticed substantial data issues that I don't know if the senators are aware of. The data in the table has been altered. For instance, Native Americans, to suggest that complaints are not as bad, or not as disparate, or not less discrimination is in the system. And the tables, if you look at it, Native Americans were increased 141% between the two tables, which is supposed to mean the same exact factor calculation. Blacks 85%, Asians at 49% of a change. And this was reflective in trying to reduce the overall numbers to show that there was no disparate impact and discrimination within the board's procedures. Additionally, critical variables are missing from the report, such as, and I think this is what patients really want to get to, is that there's no demographic information that deals with the people that are actually making these decisions. That means we don't know the race or ethnicity of any of these investigators, the consultants, or the experts. These are critical variables that we need to know when these cases get assessed. There's also no data on whether or not these complaints are coming from hospitals or whether they're coming from patients. Black physicians have complained a lot about being asked to leave communities and threatened. to the communities, and if they don't, being threatened with complaints of 805 reports. Here is my resolution. First, the CRB report was inaccurate, grossly flawed, and I believe two things should happen. Either the CRB should go back and reproduce a report, or it should be an independent external report done to include, number one, the missing variables that I mentioned earlier. For discrimination purposes, every hospital should be turning in an annual report of those providers' demographics who actually apply to that hospital, which includes even a pre-screening process, which they now have in place, to anything from denial to acceptance. Number three is to resolve this issue of implicit bias, discrimination, and a disregard for patient safety. My recommendation is that someone deal with Dr. Krause to ensure that he is active on that task force. Indeed, I agree there should be probably equal numbers on that panel for physicians and non-physicians, but at the same time, the task force should be able to have a committee of interested, invested people to deal with health equities and to really get to the bottom of what's happening on this board. I appreciate you for your time. I am concerned about the inaccuracies of the CRB report, that it needs to be done, and I support us improving public welfare, because even right now in California, there is one hospital who's under federal investigation for denying Black surgeons the opportunity to practice. I think it's atrocious, and these are the kind of things that we don't need in healthcare, because this is what sets us up for patients not being able to access quality of care. Thank you so much for your time.
Doctor, thanks for your testimony. Moderator, next, please.
Thank you. Line 106, please go ahead.
Hi, this is Christina Hildebrand from A Voice for Choice Advocacy. I just wanted to commend TJ Watkins for doing as what he always does in the medical board meetings, which we attend every single quarter, which is speaking up and trying to shake the board up. So I really hope that the legislature listens to what he had to say and recognizes what everyone else has been saying, which is that the trust in the public trust of the medical board is just not there. One of the underlying things that I'd also like to point out is that while the physician public membership is definitely an issue, and it would be better to have more public members than physicians, one of the other key issues is the fact that all of the physician members are members of the California Medical Association. And the amount of lobbying that the California Medical Association does to the medical board, and they are two very different entities, is amazing. And the fact that, you know, I think only 40% of physicians in California are part of the California Medical Association, and the majority of those are residents and people that are still in medical, getting their medical degrees, and or in the first few years out of school. Most of them are not the physicians that are, you know, have been practicing in California for many, many years. So the California Medical Association really is not representative of physicians in California, yet the medical board is made up, majority physicians who are part of the California Medical Association, and they absolutely are lobbied and biased by the Medical Association. And so I would really ask the legislature also to look at that and to ensure that when physicians are promoted or, you know, put in place on the medical board, that they come from a range of physicians, and that they are in the same representative scope part of the California Medical Association, or cut off the ties with the Medical Association, which is a lobbying and advocacy association. That's my comment. Thank you so much.
Thank you. Next, please.
Thank you. Line 107, please go ahead.
Hello?
Line 107, you are now open.
Oh, good. Oh, I'll be brief. My name is Ima Gast. After 6 hours, I simply don't even know what to say, other than perhaps I am now convinced that the California Medical Board may well be the most corrupt entity in the entire Golden State. And this is a bold statement, given the corruption of the DMV, EDD, CPUC, teachers unions, and so many other decaying institutions in the state of California. And you, the legislature, are totally and entirely responsible for this. And it's high time that you remember that you work for the people of California. Those 2 million signatures may well come for any of you next, Senator Roth. And be sure to tell Dick Pan, because he probably ran off, which is what he does.
Thank you, ma'am. Next, please.
Thank you. I have no further comments in queue at this time.
Fine. For the record, I will note that for those who think we don't take public comment, we have almost had 2 hours of public comment at this initial Medical Board Sunset Review oversight hearing, with at least one more scheduled in the future. So for those of you who did not have a full opportunity to make your comments, one, I would ask that you submit them in writing, and two, I would also ask that you tune in for the next session and take advantage of that public comment opportunity as well. I'd like to thank the members of the committees and our witnesses for their testimony today. I would also like to thank each and every one of you, members of the public, for sharing your stories and for weighing in on the issues that we were addressing and have been addressing today during these proceedings. Enforcement by the Medical Board, which is the subject of this oversight hearing, is key to ensuring that public trust remains with this most important of professions. It's pretty clear to me, I think it's clear to my colleagues and clear to all who listen today, that there is still much work to be done with regard to many concerns on a variety of issues having to do with the Medical Board of California. We have additional hearings, as I indicated a minute ago, planned to review the Medical Board's operations, its work, processes, and efforts to ensure quality patient care, and will announce those dates in the coming weeks as details are confirmed. Once again, let me say, if you were not able to testify via the telephone conference service today, and for those who did participate but wish to do so, please submit your written comments or suggestions to the Senate Business, Professions, and Economic Development Committee or the Assembly Business and Professions Committee, or both, or visit our website. I can assure you that your comments and suggestions are very, very important to us, and we want to include your testimony in the official hearing records. Thank you. We appreciate your participation. Thank you for your patience and your cooperation. We have concluded the agenda for today. This joint Sunset Review oversight hearing is adjourned.